Check, check. Mic check. 3, 2, 1, 1, 2, 3. Microphone check, check. Mic check. 3, 2, 1, 1, 2, 3. Mic check. Check, check. Mic check. 1, 2, 3. Straight at the correct channel. Is that part manual? Check. Check, check. Mic check. Check, mic check, 3, 2, 1, 1, 2, 3. Microphone check, 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 check. Mic check. Reading? Anything? Mic check, 3, 2, 1, 1, 2, 3. Microphone check, check, check. It jumped though. No movement.
Good morning and welcome to the first hearing of the Special Select Committee to investigate document communication and processes tied to the signing of the document titled Definitive Agreement. This is the first of the series of hearings, and I will not spend a lot of time because this is to be run by members of the Senate, and the Senate has chosen a chairperson, Senator Janelle Chanona, and so I hand the mic over to her to carry on the proceedings. Senator Chanona.
Thank you, Clerk. Good morning. To advise the nation that we have just commenced today our 9th meeting of the Senate Select Committee. We have now moved into the public hearings portion of our work. The folder and documents you see in front of me represents all the correspondence, the exchanges, and the documentation in part that the committee has been reviewing since its first meeting on August 15th. I am directed by the clerk that the first order of business of the public hearing is to read in full the motion. The motion for the appointment of a special select committee to investigate all documents, communications, and processes tied to the signing of the document titled Definitive Agreement by and between the Government of Belize and Portico Enterprises Limited, DBA, the Port of Magical Belize, dated October 1st, 2020, and to investigate all documents, communications, and processes that resulted in the document titled Definitive Agreement by and between the Government of Belize and Portico Enterprises Limited, DBA, the Port of Magical Belize, dated October 1st, 2020, being presented to the Cabinet accompanied by draft legislation as attachments to Cabinet Confidential Memo 84 of 2023, dated May 15, 2023. Whereas paragraph D of section 61A2 of the Constitution of Belize provides that among the powers and functions of the Senate is the instituting and conducting of inquiries and investigations on any matter of public interest or importance, at paragraph G thereof requiring the attendance before it of any chief executive officer in a government ministry in respect of any matter of which he has knowledge by virtue of his office, or in respect of anything related to his office and the due execution of his duties, and that paragraph H thereof requiring the attendance before any committee of the Senate of any minister of government. And whereas the public has become aware of a signed document titled Definitive Agreement by and between the Government of Belize and Portico Enterprises Limited, DBA, the Port of Magical Belize, dated October 1st, 2020, and given that that document has subsequently been presented to Cabinet along with draft legislation as attachments to Cabinet Confidential Memo number 84 of 2023, with certain recommendations from the Ministry of Finance, Economic Development and Investment in consultation with the Ministry of Tourism and Diaspora Relations, and within the context of questions regarding the legality of the contents of that document. And whereas the government has committed to, quote, fight corruption and, quote, work to restore confidence in government, unquote, and tabled same in a good governance motion in January 2021 to signal, quote, serious about meaningful reform and open and accountable governance, end quote, to all Belizeans. And whereas the government acknowledges and heeds the call of the citizenry, including several of the social partners represented in the Senate through the Belize Chamber of Commerce and Industry and the Belize Business Bureau, the National Trade Union Congress of Belize, the Belize Council of Churches, and the Evangelical Association of Churches, and non-governmental organizations, in recognition that the chronology, communications, and legality tied to and related to this agreement are matters of public importance, and that in the interest of ensuring good governance and compliance with organizational best practice and statutory requirements, it is desirable that the Senate exercises its powers and functions under the Constitution of Belize to conduct an inquiry into and investigate this agreement. And whereas Standing Order number 69 of the Senate Standing Orders, which are further herein referred to, provides for the appointment of a special select committee other than a standing committee by order of the Senate, which shall specify the terms of reference of that committee, including its composition. And whereas Standing Order number 70 provides, among other things, that every select committee shall be so constituted as to ensure as far as possible that the balance of the parties in the Senate is reflected in the committee. And whereas Standing Order number 72 provides authority to enable the special select committees to summon witnesses to a sitting thereof, now be it resolved that the Senate shall approve the appointment pursuant to Standing Order 69 of a special select committee of the Senate, hereinafter referred to as the committee, with the following terms of reference and composition. Terms of reference are: A, to conduct an independent and impartial investigation and inquiry into the signing of the document titled Definitive Agreement by and between the Government of Belize and Portugal Enterprises Limited, DBA, the Port of Magical Belize, dated October 1st, 2020, and to determine which, if any, established procedures and or investment policies were followed, to determine what advice, policy, or basis the Ministry of Finance, Economic Development and Investment, in consultation with the Ministry of Tourism and Diaspora Relations, relied upon to prepare Cabinet Confidential Memo 84 of 2023, recommendations and draft legislation, and subsequently submitted for Cabinet's consideration and approval, into all communications and documentations tied to the document titled Definitive Agreement by and between the Government of Belize and Portugal Enterprises Limited, DBA, the Port of Magical Belize, dated October 1st, 2020, into all communications and documentations tied to the document titled Definitive Agreement by and between the Government of Belize and Portugal Enterprises Limited, DBA, the Port of Magical Belize, dated October 1st, 2020, being presented to Cabinet along with related draft legislation as attachments to Cabinet Confidential Memo number 84 of 2023 in May 15, 2023, with certain recommendations from the Ministry of Tourism and Diaspora Relations. B, to require the production of such communications and documentations, papers, and records as the committee shall deem relevant to the inquiry and to examine pertinent documentation. C, to determine whether, consequent with the investigation and inquiry, statutory and other procedures were complied with. D, to require the attendance before the committee of former ministers of government and current ministers of government, signatories of the agreement, and or those who may have information by virtue of his office which may be relevant to the inquiry pursuant to section 61A(2)(g) of the Constitution of Belize. To require the attendance before the committee of those heads of departments, regulatory committees, or those who may have information by virtue of his office or responsible for and involved with the issuance of environmental compliance, clearance permits, et al., and or any other official of government who may have information which may be relevant to the inquiry pursuant to section 61A(2)(h) of the Constitution. To require the attendance before the committee of all such current former public officers in the ministry responsible for the ministries of investment, trade, economic development, finance, tourism, etc., as well as those responsible for ports, environment, etc., pursuant to Standing Order number 72 of the Senate Standing Orders, as well as to produce all relevant communication, papers, and records of the ministry, departments, etc., as may be necessary to conduct its inquiry and investigation. G, to examine all persons required to attend before the committee as witnesses pursuant to Standing Order number 72 of the Senate Standing Orders. H, to hold and conduct its sittings and meetings in public and broadcast live, except for sittings which are only held for the purpose of deliberation of matters which are subject to the committee, which sittings shall be held in private. I, that the committee shall hold its hearings with due urgency and expedition in accordance with Standing Order number 75 of the Senate Standing Orders, make a report to this Honorable Senate as soon as may be practicable of the result of its inquiries, with all such comments and recommendations as the committee may deem fit, furnishing this Honorable Senate with a full statement of its proceedings and the reasons leading to its conclusions and recommendations. That the report shall be tabled in this Honorable Senate and become a public document. All committee members shall be allowed sufficient time and equal opportunity to question witnesses and shall be permitted to question each witness who attends the sitting. Each witness shall be afforded the opportunity, pursuant to Standing Order number 7213 of the Senate Standing Orders, to review his/her evidence and the findings of the report, and shall have the opportunity to suggest corrections due to inaccurate reporting within 14 days of the date from which the report was sent to the witness by the clerk. The committee shall be permitted to hire attorneys, accountants, and such other experts as may be required by the committee And N, the office of the Senate shall be the office of the Secretariat of the committee. The composition of the Special Select Committee, that the committee shall be appointed consisting of 7 senators as follows: 2 from those appointed on the advice of the Prime Minister, 1 from those appointed on the advice of the Leader of Opposition, the 1 appointed on the advice of the Belize Council of Churches and the Evangelical Association of Churches, the 1 appointed on the advice of the Belize Chamber of Commerce and Industry and the Belize Business Bureau, the 1 appointed on the advice of the National Trade Union Congress and Civil Society Steering Committee, the 1 appointed on the advice of the non-governmental organizations. B, senators who are members of the committee shall at the first meeting of the committee elect a chair of the committee, and the quorum of the committee shall be 4. As a matter of notice, I'd like to share that the Honorable Senator Elena Smith is away on official duty, hence her absence at today's first proceedings. Without further ado, Clerk, can we please ask the Honorable Tracy Panton to join us as the committee's witness? Good morning. Good morning, Honorable Panton, and thank you for affording us your time today. Yes.
Good morning.
We'd like to afford you the opportunity, if you'd like to use it, to make any opening statements to the committee, if you would like.
Good morning to the members of Madam Chair and the members of the Senate Select Committee. I believe that this is a very important hearing, and so I would like to recommend, Madam Chair, that given the importance of this undertaking, that when members are served, that they are served personally. I got an email correspondence inviting me to this hearing, and I really do believe that greater consideration should be given to members of the National Assembly. 2, I served in cabinet from 2015 to 2020 as the Minister of State in the Ministry of Economic Development, Petroleum, Investment, Trade and Commerce. In that capacity, I was asked by the Prime Minister to provide the administrative support and oversight of portfolios of the investment, trade and commerce. I was also appointed by the Cabinet to serve as the chair of the Cabinet Subcommittee on Investment. That committee was tasked with the responsibility of reviewing proposals that came to the government, investment proposals that came to the government, where particular incentives and support was required from the government of Belize. On that committee sat the Deputy Prime Minister, who was at the time the Minister of Education, the Attorney General of Belize, the Minister responsible for tourism, the Minister responsible for agriculture, the Minister responsible for natural resources. In addition to that, the Beltrade, which is the investment unit of the executing agency for investments for the government of Belize at that time, served as the secretariat, if you will, of the Cabinet Subcommittee on Investments, supported by the investment unit within the Ministry of Economic Development, Petroleum, Investment, Trade and Commerce. All recommendations made by this committee was sent for further consideration to Cabinet via Cabinet memos at every stage of the process. So Beltrade and the investment unit had a 7-point process for looking at projects that came before the committee, which started with the pre-screening of investors and ultimately recommendations for definitive agreement if and when that was necessary. In some cases, there were projects that went a step further, step number 8, which would require a decision by the National Assembly of Belize for legislation to be passed. In the case of the Portico project, there was a memorandum of understanding signed between the government of Belize and the principals for Portugal. This is, as we know, a non-binding agreement that provides a framework to facilitate the further steps of the project. There was, to the best of my knowledge, no definitive agreement recommended, considered, or approved by Cabinet for the Portico project. It certainly did not come before me as chair of the Cabinet Subcommittee on Investment. I am here, of course, to answer whatever questions the committee may deem appropriate. Thank you.
Thank you very much, Honorable Panton. I will only ask the clerk to respond, as his office is the Office of the Secretariat, to your first concern on the handling of invitations.
I will certainly try to improve on the delivery of these summons or notices on the way forward. But to explain, we did send them all out by email. It might have not been acceptable, but the law is that electronic communication is now legal. And I agree with you, as an honorable member, we should reach out to you personally, and you are one of those people who are always here at the Assembly, and so I will try to improve on that. Thank you.
Thank you, Clerk. Thank you again. Honorable Panton, can I ask you just to provide a bit further context? Thank you for your opening remarks. We don't have insight into the mystique that is Cabinet and its machinations. What was the process in your time as a Cabinet Minister in terms of handling of these potential investments being proposed? Was it that everything came through the investment committee that you chaired? Was it that this was on a case-by-case basis that it was handled? Provide for us, if you will, context as to what exactly your committee was responsible for.
To the best of my knowledge, all investment projects, all investment proposals came to the Cabinet Subcommittee of Investments for review and recommendation to Cabinet. Initially, through the pre-screening stage and pre-feasibility stages, those projects would be examined by Beltrade, and Beltrade would then provide its reports to the Cabinet Subcommittee on Investments. The investment unit of the ministry would also review these project proposals in terms of a cost-benefit analysis. How many jobs will it create? How much investment dollars would be brought to the ground? When would the government see a return on investment as it relates to the incentives that are being provided by the principals of these projects? Based on that information and that analysis, the committee would then send its recommendations on a project to Cabinet via a Cabinet memorandum.
And what was the threshold for an MOU? Because you reference in your opening remarks, and we are aware that there was an MOU signed in September 2017. What was the threshold for an MOU having been signed?
Any project over $10 million US.
We have also been reviewing you referenced earlier that I think we have it now. Yeah. Apologies for that. You referenced that, as far as you're aware, there was no definitive agreement on this project. Were there other projects that were signed off on that you only came to be aware of subsequently? I'm just trying to establish what was the practice or the procedure, even for those projects that may not have come through the investment subcommittee.
I am not aware of any project not following the processes and guidelines that were put in place by the Subcommittee on Investments, or the processes and procedures followed by Beltrade and the investment unit of the ministry.
You referenced earlier as well that there was a 0.8 to your 7-point screening that was requiring National Assembly. Was there one of the points in that 7 requirement for cabinet approval? Were all projects then sent from the subcommittee to cabinet as a realm, or was the subcommittee an authorizing or binding body unto itself?
No, the subcommittee only was responsible for doing the assessment, the formal assessment of these projects based on the technical information provided by Beltrade and the investment unit. And then we would provide our recommendation to Cabinet for approval. So all final approvals was handled by Cabinet.
Can you tell us who would have been, as part of the norm, who would have been preparing agreements, contracts, any memorandums of understanding that the committee had deemed to go forward with?
By the government's attorney, which is the Attorney General's ministry, the Solicitor General chambers in particular.
And if you had to describe or define, you used the word secretariat earlier in referring to Beltrade, what then was the function, if any, of the Beltrade entity to the cabinet subcommittee in a technical or otherwise form?
Well, Beltrade was responsible for the pre-screening, looking at the initial feasibility of the projects. They served as the secretariat of the committee, so they took all minutes. They were responsible for providing follow-up letters to any investors that required a response from the committee, and also assisted in the preparation of the cabinet memorandums that were then finalized by the ministry and taken to cabinet.
And as chair, what was on hand for the committee to have in its site awareness as reference? What policies, what documents, what was the guiding principles, if you will, that the committee relied upon?
Well, we certainly relied on the Fiscal and Incentives Act. There were guidelines that were prepared and approved by cabinet as to how these projects would be handled. If I may, step 1 was project pre-screening. Step 2 was the pre-MOU stage. Step 3 was the MOU phase. Step 4, the investors had to provide a comprehensive business proposal, more comprehensive than the initial proposal that would be sent. Step 5 was the post-MOU detailed assessment to ensure that what was required in the MOU phase was complete. Step 6, the CSCI, the Cabinet Subcommittee on Investments, would then take under consideration the assessments that were done, particularly cost-benefit analysis by the investment unit of the ministry, who was supported by the Ministry of Finance. And then step 7, had to do with negotiating a definitive agreement. With the Portico project, the furthest that I recall that we reached was step 5, which is in the process of doing a detailed assessment on the post-MOU agreement. There was some agitation, if you will, by the principals to expedite, if you will, a definitive agreement based on the fact that the elections were near, and they wanted this agreement to be, this process to be completed under our administration. That was not entertained, and it was not entertained because to get to the MOU stage, there are 3 critical steps that had to be in place. 1, the environmental impact assessment had to be completed, and there had to be an approved environmental compliance plan. 2, the land arrangements for the project had to be in place. And in the case of Portico, some of the land that was being considered that was necessary for the project was in the hands of private landowners. The principals of Portico had asked the government to negotiate the acquiring of those lands for the project, and that request was denied. And third, there had to be clear commitment by a financial institution, either here or abroad, that would commit to 30% of the investment cost of the project. There were other things, but those were the 3 critical things that needed to be in place before a definitive agreement could be negotiated.
To clarifying, because I think when you began, you referenced MOU, but you were referring in fact to what was required for the definitive agreement process to be entered into, those 3 points that you referenced just now.
Yes.
Okay.
That's,
Yes.
and then with other projects, for example, with the Norwegian Cruise Line project down at Harborsky, and even the State Bank project, it required legislation because the package of incentives required approval from the National Assembly. We certainly we were no place close to that kind of discussion with the principals of Portugal.
Can you then get into further detail as to this agitation that you referred to? Who was agitating and to whom, and beyond the planned national elections, on what basis were they attempting to?
The attorney for Portugal, who, as I can recall, was David Morales, had reached out to the investment director at Beltrade. The director had reached out to me, and I didn't even take it to the committee. It was not even entertained. When Mr. Morales did not get the kind of response I think he had hoped for from Beltrade, he then sent me an email asking if the government would consider fast-tracking, if you will, the definitive agreement. And I had responded that unless the criteria that I shared with you was met, that the matter could not go before the committee. We had a subsequent committee meeting after that email was sent to me by Mr. Very informal email.
Do you remember the time of that email or the approximate date of that email?
I don't have it, but I know it was on the media somewhere. I'm sure we can find it. I don't recall. It was in 2020. It was early part of 2020, if I can recall. I don't have the date. We can verify that information. We had a subsequent meeting of the CSCI after that email, and the committee agreed that there was no way a definitive agreement could be expedited. I shared the information as a matter of information because it was my sense that the principals were reaching out to people individually to try and garner some support for accelerating the definitive agreement. So I wanted the committee members to understand exactly where I stood on the issue and that they could be aware that there was some lobbying being done for this to happen. Committee members at that meeting all agreed that we were no place close to signing or even negotiating a definitive agreement.
Did that go above the subcommittee to the wider cabinet to also advise that this agitation was occurring, or did that remain at the subcommittee?
No, I don't believe we had a cabinet meeting after the subcommittee had met the last time, but there was no need because it would not have been a recommendation of the committee for that to happen.
So when did you become aware of an agreement?
I believe it was Channel 7 who reported that indeed there was a signed definitive agreement. I was interviewed at that time by both Channel 7 and Channel 5. And I made it categorically clear then, and I will make it categorically clear now, that I was not aware. Neither did I recommend or consider a definitive agreement for Portugal.
Can I ask, and I will be deferring to my colleagues for questioning, but in your capacity as a Minister of Government, Have you ever signed an agreement that did not go through the processes that you have outlined using your authority as a minister of government in that way?
I was a minister of state, and as you know, the Constitution of this country does not recognize the role, if you will, of a minister of state. Whenever agreements had to be signed by the government of Belize, it was either signed by the Attorney General on behalf of the government of Belize or the minister, the substantive minister of the ministry, based on the cabinet approval to proceed in that fashion.
But were you aware of any such instance?
No, I was not aware of any such instances where the guidelines and procedures were not followed.
Thank you. I will resume questioning. I'll give my colleagues an opportunity to ask. Senator Bishop Bengushe, you're acknowledged.
Thank you very much, Honorable Hanton, for gracing us with your presence today. I just want to ask you one question. As one who served as a minister in the previous administration, and perhaps thank you. Yes. As one of the ministers who served under the previous administration, and perhaps just taking us down the road a little further, was, as you all discussed in cabinet, was there any previous perhaps discussion or agreement within the cabinet that some things shared by the cabinet was sealed information and could not be shared with the Belizean public?
As far as I understand it, Senator Bengushe, cabinet memorandums are confidential in all cases. If I can add, and maybe this may be helpful, there are duplicate files. I learned very early in my career, Senator, to keep copious notes. And I can assure you that both at Beltrade and in the Ministry of Economic Development, the investment unit in particular, there are copious files with all investment projects that were considered and entertained by the Cabinet Subcommittee on Investment.
Senator Herrera.
Good morning again, Honorable. Thanks for appearing for us this morning. I have a few questions, and I'll start out in relation to the Cabinet Subcommittee meetings. How are the agendas for these meetings set?
The agenda for the meeting was determined by the project proposals that were under consideration or had been sent to Beltrade for consideration for fiscal incentives.
And this committee would meet when such a proposal would come before it, and that would probably be triggered by cabinet?
No.
Discussions?
Cabinet didn't trigger the meetings.
Okay.
The meetings were held so that we could come up with some collective position or recommendation to cabinet on a particular project proposal. The committee met quite regularly. I'd want to think we met maybe once a month because there were so many project proposals before us, big projects, State Bank, Waterloo, Portico. So there were the National Gas Company. There are a number of projects that were before the committee that required us to do our due diligence.
Right. So the projects would come to the particular ministry first, and that would then trigger the investment committee to meet on that particular investment proposal. Am I right?
The clearinghouse for project proposals was Beltrade. And so projects would be filed with Beltrade, and then they would notify the ministry of what project proposals were before Beltrade. We would also look at and they would provide for us information on the project pre-screening process in terms of, we had to make sure that the investors, for example, were bona fide investors, that the projects fell within our priority sectors for investment, because we had a list of priority sectors, tourism being one, of course, agriculture, energy. So we would look at those priority sectors to ensure that these projects fit that kind of frame.
So Beltrade would do, you're saying Beltrade would do all the groundwork prior to that meeting that would be held by the subcommittee?
Okay. So certainly Beltrade, and where it was necessary before we got to the cost-benefit analysis phase, would seek the support of the investment unit, or would seek the support of Interpol, or because no project should come before the committee if we didn't do some pre-vetting of the proposal or the principals responsible for the project.
Good. And Portico would have been one of those investments that would have been discussed at the Cabinet Subcommittee.
It was discussed at the Cabinet Subcommittee on Investment, and it was also discussed in Cabinet.
Was there any, and I think you had touched on this earlier, but just for clarity, there was never any recommendation coming from this committee that this investment was recommended by the committee?
There was a discussion at Cabinet to get into a memorandum of understanding with Portugal. There was no discussion or recommendation by the CSI to Cabinet to have a legally binding agreement, which would have been the definitive agreement.
Was there any discussion or recommendation coming from the subcommittee that that any type of exemption from taxes, duties, or that type of thing should be afforded the Portico investment?
We had not gotten to the point where a legally binding agreement would have been considered for Portugal, or to make any determination what incentives government would be prepared to offer to facilitate that investment.
And I guess that would also include, because these would be subjected to a definitive agreement, duties, capital gains. You didn't reach that far.
Could you repeat that question, please?
As a follow-up to your answer just now, these would also include that there would have been no recommendations on duties or capital gains, exemption from those, because those would have been at the agreement stage.
It would have been either at the agreement stage or when the matter or legislation had to be drawn up to facilitate the project. And we were definitely not there.
And that would also hold true for any recommendation and a tax break for 30 years.
We had no discussion on any hard and fast fiscal incentives for the Portico project. There was no draft legislation for the Portico project. There was no definitive agreement for the Portico project. Certainly, if this is what you're trying to get at, did the Portico principals made such requests, certainly, but that was not considered by cabinet or recommended by the committee.
Would an exemption from all taxes, duties, capital gains, would that be out of the normal for a project of this nature?
But can you detail for me what taxes are you referring to?
Well,
When you say
the
all
definitive
taxes,
agreement says any and all taxes.
there was no definitive agreement, so I don't know what document you're referring
Well,
to.
yeah,
But
let me clarify.
There has been no definitive agreement before us.
Good point. Good point. But there is a document circulating in the media with some signatures that were reported to be the definitive agreement. So
Well,
I'll
for me,
withdraw.
that's all speculation,
Yes.
Senator, because
Point taken.
I did not receive any draft definitive agreement as chair of the committee for consideration. I
Point
did not
taken.
review any draft definitive agreement. I did not recommend any draft
Yes.
definitive agreement. So as far as I'm concerned, there was no draft or approved definitive agreement.
Let me rephrase my question. Would exemption from any and all taxes, capital gains duties, exemption from taxes for 30 years, would those type of exemptions be out of the ordinary for investments?
For the projects that
That-
came before the Cabinet Subcommittee on Investment, when I chaired that committee, yes, it would have been out of the ordinary. And any such package of incentives of that magnitude as you have described would require the approval of the National Assembly.
And these discussions with respect to those exemptions never made it to cabinet because they were never in committee in the first place. They were never discussed in the CSI in the first place. Am I right in assuming that?
I hope I have made myself clear, and if not, let me try again. There was no definitive agreement brought before the Cabinet Subcommittee on Investment.
Right.
There was no definitive agreement recommended to Cabinet by the Cabinet Subcommittee on Investment when I served as chair. There was no definitive agreement discussed in Cabinet when I served as chair of the Cabinet Subcommittee on Investment. I hope that answers your question.
Yeah, I think you're clear on we're clear on the definitive agreement, but I was looking at some of the terms that have been floating around, and so I wanted to get a feel of whether or not those type of terms ever entered into any type of discussion. And if I'm gathering from what you're saying, it never reached that point because those never came before you.
That's exactly my response. You keep referring to a document that I certainly have not seen.
Understood?
Yes.
Are you aware throughout your time on the Cabinet Subcommittee of any project that did not go through the process that was authorized?
No.
Beltrade, you said Beltrade rules is one of provide the secretariat as well as do some assessment and some other work. Who holds the records that are discussed in those subcommittees? Is it Beltrade, or are those filed somewhere in some other ministry?
As far as I am aware, there are duplicate files at Beltrade and within the investment unit in the Ministry of Economic Development. Beltrade was the executing agency for government for investments. They served as the clearinghouse and they served as the secretariat, if you will, to the Cabinet Subcommittee on Investments. They took the minutes and they prepared follow-up correspondences to the investors that they had an interface with.
Yeah, those conclude my questions at this point. Thank you.
Thank you, Senator.
Thank you, Senator. Senator Powell?
Good morning, Honorable Panton.
Good morning.
Thank you for coming this morning. I have a few questions for you. Earlier you mentioned, if I can recall, that as far as you're aware, this project that we are looking at, the definitive agreement, was at stage 5. Correct? Can you recall at what point that was? And I'm referring to dates, months, year.
Sorry, can you repeat the question, please?
Yeah, so earlier you mentioned that as far as you're aware, this document, the definitive agreement, was at stage 5. At what point was that? And I'm looking at dates, and months or year.
Okay, so stage 5, if I can read from my notes,
Sure.
include the post-MOU detail assessment. We were in that process. So that included final screening of the project's viability, the technical capacity of the investors to actually execute the project, and the financial capacity of the company's principals. It also included the process of validation of access to financial capital by the company's principals. 30% of the total forecasted investments for the project was a minimum requirement. It also needed to have access, legal access, had to prove that they had legal access to the property that the project was intended to be built on. There was also the need for stakeholder validation.
Yeah.
So at some point in this process, which did not happen, this process, we were at the beginning of this process, as far as I can recall, technical validation had to be provided by the relevant government ministries, the NGO community, and this has nothing to do with the environmental impact assessment. So, for example, because it's a project that was a port facility proposed to be, the Port Authority would have been engaged, the Ministry of Tourism would have been engaged, anybody that would have input into ensuring that the project was viable and should be given government's consideration in terms of fiscal incentives and support.
So I was asking about
I'm not finished,
Sure.
if I may complete my response. It also included the process that the investment unit of the ministry was responsible for, which is the cost and benefit assessment. And that, as I said, was a responsibility of the Ministry of Investment, Trade and Commerce. That was step 5 in the process, and we were just at the beginning of that process, as best as I can recall.
Yeah, I was asking about the timeline of that stage 5, like at what month? Was it in May? Was it in January of what year?
I really don't recall, but the minutes should be there for your review.
And as far as stage 5, obviously the then government was entertaining such project. Were they meeting all the requirements, at least stage 1, stage 2, stage 3, and reaching that stage 5?
They met the project pre-screening step. They met the pre-MOU phase. There was an MOU signed between the government of Belize and the principals for this project, and they had submitted a very detailed business proposal for the consideration of the committee. That's where we were.
Yeah, and earlier you said that at every step of the way there was a cabinet memo that would be presented to cabinet, obviously. Who would present that memo to cabinet when it comes to this project?
The cabinet memorandum was prepared by my office, and I would do the presentation in cabinet on the details for cabinet's consideration.
So, which means that stage 1 to stage 5 of the process, you made that presentation to cabinet?
For cabinet's consideration, yes.
Earlier you said that the attorney for Portico wanted to fast track this process. Are you referring to the Morales and Perifit LLP?
The attorney on record for the Portico project, as far as I am aware, was Mr. David Morales. He was the attorney that reached out to me. I know that email has been widely circulated in the public domain.
Another question, when it comes to at least these stages, at least when it comes to the attorney, obviously at every stage there's an attorney there. Is it a norm for these the attorneys for these private entities also engage with the Aegis Ministry when it comes to, at least at every stage of the process?
Let me see how best I can answer this. So the principals would share with the government what their ask is. You know,
Right.
if they're asking for whatever the ask is. And based on that information, we would engage the Attorney General's ministry. So that is done by the Secretariat, which is Beltray. And then we would, if necessary, we would share a counter proposal with, we're negotiating a counter proposal with the principals, and at some point, we hope to find an agreement. That is done at the MOU phase, and that is also done at the definitive agreement stage.
If I understood what you said, that the attorneys for these private entities would engage the subcommittee, and the subcommittee would engage the AG, or is there a direct contact with the attorney to the AG?
The private attorney for the investor?
Yes,
Is that
to
the
the
question?
AG.
No.
No.
So if based on what is submitted to the committee requires further information or clarification, what would happen is that the principals for this project would be called before the committee. Many times, they would have an attorney with them or their financial advisor with them. And then based on the information that we gather at those meetings, then we seek the input of the Attorney General's ministry. At no point, to the best of my knowledge, is there any engagement by the Attorney General's ministry directly with a private attorney for the project. I say that because the Attorney General was also a member of the Cabinet Subcommittee on Investment.
The attorney was asking to fast track the process. Was it only the attorneys, or was there any member of cabinet or government that was also in favor of at least influencing that process?
The only email I got was from Mr. David Morales. I had certainly, as I said, I advised my colleagues on the subcommittee so that they could be aware that I had received that email, and certainly this was the intention of the principals. But I did not have any intervention from any colleague, those who sit on the Cabinet Subcommittee on Investments and those who sat in Cabinet, to fast track anything for Portugal.
Thank you.
Senator Bennett Moody.
Good morning, Honorable
Good morning.
Tracy Penton. Thank you for being here. And thank you for giving us that introduction earlier. It has set the stage for much of what we are understanding as this committee. I have a few questions for you. And for the purpose of the Belizean people and for this committee, could you describe for us, to your best knowledge, what is a definitive agreement?
A definitive agreement is a legal binding document that sets out, for the purposes of an investment project, exactly what government undertakes to do to help to facilitate the project and the commitments that the investor is making to the country in terms of the investment itself.
Okay, thank you for that. So that in itself is what, from your knowledge, is a definitive agreement, right? You had presented different stages earlier in terms of how a definitive agreement is established or how it's approved, those 7 steps that you outlined earlier. If it went through those 7 steps or the 8 steps, which I need for you to identify what is the 8th step, does that then constitute a definitive agreement?
Oh, no. If I did make that clear, let me. When a project is being assessed, when a project is being considered, an investment proposal is being considered by government, there's a 7-step process which I outlined. That has nothing to do with the definitive agreement. The definitive agreement is one step, the final step in that process, unless there's a need to bring the package of incentives for approval to the National Assembly, which would then be step 8, the final step, where legislation is drafted, debated in the House and approved by the National Assembly, sent to the Senate for ratification before it becomes law. So at each stage is a process to either advance the project or to say to the principals, no, this project does not meet our priority sectors, for incentives. So it doesn't mean that the investor can't invest, but it means that there would be no facilitation by government for incentives to be provided.
Okay, so let me see if I understand you right. Those stages or the steps that you outlined affords for confirmation between government and a principal. A definitive agreement is then activated at that step 8 point.
I'm not sure if I understand the question, but let me try. When a project proposal is sent to Beltrade for consideration, right? Because Beltrade, as I said, is the executing agency of the government for investments in the country, at least when I served in cabinet. I believe it remains the same. A project is then assessed via or advanced or not advanced, depending on these guidelines that was approved by cabinet. So the first step, if I can repeat, Madam Chair, is the project pre-screening step. If you pass that step, you go to step 2, which is the pre-MOU phase. If you get through the pre-MOU phase, then an MOU is negotiated between the government and the principals. That MOU is a non-binding agreement. It's just a framework, if you will, that sets out government's intention to help to facilitate this process in looking at the project in a serious way. Step 4 is a detailed submission of the business proposal for the project. So initially, a project proposal would be sent. That is how it gets on the table for the first place. But we need to have a formal business plan that, gives us, in particular, the numbers, right? How much is going to be invested. What is the marketing strategy? What are the phases and timeline of the project development? What are the economic benefits, for example? There has to be some financial validation. What's the process for environmental clearance? What steps have they taken? What steps are pending? Whether or not they have engaged with the Central Building Authority, for example. And whatever supplemental documents that the committee may decide it requires. Once that happens, then we get to the post-MOU detailed assessment. So all that information is brought together, and then we said, okay, they have met the commitments that they say they would meet in terms of this investment, and also it's for them to determine if government has facilitated them as was outlined in the MOU. When all of that is done, a formal report is sent to the Cabinet Subcommittee on Investment for an assessment. And there were 5 criteria that the Cabinet considers. Whether it's socially and economically acceptable, and if it's legally doable, if it will bring revenue to the government, if it brings meaningful employment to Belize, if it brings foreign exchange to Belize, and if it preserves or possibly enhances the environment and respect for the cultural heritage of the country. Once the Cabinet Subcommittee on Investments have looked at the project from that criteria, then, only then, would you get into a process of negotiating a definitive agreement.
Thank you for that, Honorable Panton. So, again, when does a document become a definitive agreement?
When a definitive agreement is drafted up.
And this definitive agreement would normally in process be drafted where?
At the Attorney General's Ministry.
Can you recall for us the members of the Cabinet Sub-Investment Committee? You had outlined the positions, but by purpose of names.
The Deputy Prime Minister and Minister of Education at the time was the Honorable Patrick Faber. The Attorney General was the Honorable Senator Michael Perifeet. The Minister responsible for Natural Resources was the Honorable Hugopat. The Minister of Tourism was the Honorable Manuel Heredia. The Minister of Agriculture was the Honorable Godwin Hulse. I served certainly as chair in my capacity as Minister of State in the Ministry of Economic Development, Petroleum, Investment, Trade and Commerce. Also on the committee, as I said, our Chief Executive Officer at that time was Mr. Dwayne Belize, The investment director at Beltrade was Mr. Hiro Balani, who attended those meetings on behalf of Beltrade.
Thank you.
And I'm sorry. And then the director of the investment unit was Mr. One second, let me, just so that we can, sorry. Lincoln Blake, Mr. Lincoln Blake.
Thank you. How long? How long did you serve in that capacity as chair for the Cabinet Sub-Investment Committee?
During my term in office.
During your term in office, then, as the chair for the Cabinet Sub-Investment Committee, did you come across or had to review any other definitive agreement for the country of Belize?
Yes, there's certainly the agreement with State Bank. There was a definitive agreement for Norwegian Cruise Lines for the Harvest Key project, and there was the definitive agreement for the National Gas Company.
Thank you. Can, from your recollection, share with us whether any of those definitive agreement that you have listed entailed what would be referred to as a confidential clause?
They may have. They may have.
You would not be able to recall the extent or which one of those definitive agreement would entail a
I can't recall, but I'm sure that those definitive agreements are available.
From your knowledge, having served as a Minister of State and as the chair for the Cabinet Sub-Investment Committee, can you share with us and with the nation if there's a deadline for Cabinet decisions as it relates to investment at this magnitude in terms of definitive agreement? Is there a deadline?
Well, the deadline would be indicative of how the process that I outlined, the 7-point process, is advanced. You know, we don't start a process by saying, oh, we have to get this done in 3 months. No, it doesn't work that way. There are commitments that the investors have to meet, and there are support that is expected from the government. And so as each stage is advanced, then we get to the next stage. There is no definitive timeline. The EIA process, for example, can be quite time-consuming. And so that certainly was a requirement before any definitive agreement could be considered.
From your best judgment, then, as a former Minister of State, what would be a best timeline for any such agreement to be signed by the government of Belize with any principal or with any major investment?
Well, I'm not sure that I can answer that question. I can't answer that question because it really depends on whether or not a project gets to that stage, whether or not there is a definitive agreement that the parties both are willing to support, whether or not the cabinet will give its approval for such a definitive agreement. So it varied depending on the nature of the investment and how long the processes took in terms of getting to that stage in project facilitation.
So based on your answer, if one administration is at a certain point of evaluating a definitive agreement, as it evolves, then there could be continuity in terms of another administration taking over?
I really am sorry. I don't even think that's an appropriate question, Senator. And I say that because there was no definitive agreement before the administration that I was a part of. There was none tabled, there was none reviewed, there was none considered, there was none approved.
So, for knowledge purposes, when is a definitive agreement final for government?
To the best of my knowledge, a definitive agreement is final when the negotiations are completed, when the approval of cabinet is finalized, and when that agreement is signed.
Can you clarify for us then what would be the name document as it goes through the different processes or the different steps as you outlined?
There are two main documents, if that's what you're asking, Senator. There's the Memorandum of Understanding that is signed between the principals of the project and the government of Belize. And then there is a definitive agreement, which is a legal binding agreement that outlines the commitments of government to the project and also holds the investors and the developers accountable to the investment that they intend to make in the country. Once that agreement is signed, if the package of incentives that may require the approval of the National Assembly, a piece of legislation is drawn up and then brought to the National Assembly for debate and consideration, approval, and then it goes to the Senate to be ratified before it is signed into law by the Governor General.
Thank you. Senator Williams, you have any questions at this time? Okay. We yield to Senator Bishop Bengushe.
Thank you very much, Madam Chair. Honorable Panton, just one additional question. And I hate to assume, but based on what you have shared with us, can I say that based on when your term, your government term would have come to an end, that the memorandum of understanding to which you were referring would have only reached stage or step 5? Can I assume that based on when you all would have left office from where you sit, that it would have only reached stage 5?
Senator, that's not an assumption, it's a fact.
Good. Thank you.
Senator Kawa.
Honorable Panton, at stage 5 of the process, and you said earlier it was the beginning of stage 5 of the process, if I'm correct. What was the recommendation at that point? Was it for the project to go ahead? Was the government in favor of the go ahead to complete stage 5 and then move to stage 6?
Sorry, Senator, no. We had not completed the assessment that is required in stage 5. So there would have been no cabinet memorandum to the government to say now we are ready to move into negotiations for a definitive agreement. No.
So it was just basically waiting to complete stage 5.
We had completed stage 4.
And
we were in the process of looking at the elements as outlined in step 5 of the process. But we had not come to a final conclusion, and no memorandum was sent to government for its consideration.
Earlier you mentioned that the attorney for the Portico wanted to fast track the process, and they wanted to get it done under the last administration. Did they give any reason why they wanted that in the email that was sent to you?
No, but I'm sure you will have him before this committee, and you can ask him that question directly.
Right. Earlier, you also mentioned that when my colleague asked about other definitive agreements, can you recall who were the signatories on those agreements? At least for the cruise port.
It was normally the practice that the Attorney General's ministry sign off on those agreements.
Just the Attorney General's ministry?
There may be a witness. There's also a party for the principals that would have to. It's a binding agreement between two entities.
I'm asking about the government side, like it's not the Ministry of Finance or anything like that.
No. So what happens that when government approves, and then government would then appoint entity, and to my recollection, it is the Attorney General's ministry that was asked to sign off on those definitive agreements.
Thank you.
You're welcome.
Would you like a break? I know you. Thank you, Honorable Panton. I just have a few more questions, if you will. I'm trying to understand the power dynamic. There was a Minister of Investment, there was a lengthy portfolio name, and then there was a subcommittee. But was there ever, the process you've outlined is, it came through the Beltrade and subcommittee, and then it went up to cabinet. But was there another avenue for other projects that went directly to the Ministry of Investment and Economic Development and then to cabinet, if there were other tracks there?
Not to my recollection, no.
When you were reviewing as subcommittee, and you mentioned other port projects had already gotten to a certain stage, were these projects being looked at individually or as a part of, in looking at economic feasibility, at looking at environmental costs, at looking at the wider benefits outline, as you said the committee was being guided by? How are those being assessed?
Sorry. Where the expertise was available within the ministry, certainly the ministry's officers would be looking at the feasibility of a project. For example, the investment unit did the cost-benefit analysis. Environmental costs or impact was certainly not assessed by our ministry. It had the involvement of the Ministry of Natural Resources and NEAC. Wherever there was an expertise required, that expertise was brought to the committee for discussion and review. So projects, to answer the first part of your question, projects were considered based on their individual merit in terms of investment into the country.
So the even geographic vicinity of the location of it did not play a direct role in any kind of overall decision making?
It would have. Certainly, there were those discussions of whether or not projects were too close to each other. There were 3 projects on the table at that time. So we had State Bank, which had already received its approval. There was the Waterloo project proposal. Sorry. And of course, there was the Portico project consideration. You will recall, Senator, that there was a case decided by the Supreme Court of Belize that there would be no exclusivity provided to any.
Take a break.
Sorry, any exclusivity to any developer. And so these projects were considered based on the merit and the level of investment of the projects, and would have been guided, had we gotten to that stage, by the input of, for example, NIAC or the Ports Commissioner, or where that relevant expertise was necessary.
In hindsight, would that still be the order you would have maintained, given that perhaps developers would have felt that they had gone along a process only to be told at the end, yeah, this not work, that there was some type of maybe a timing issue for certain things?
No. When an investor comes to the table, the investor or the developer is told what the process is. They don't enter this process blindly. They understand the steps that the government will take, what that entails, et cetera, et cetera. So it's not that investors are led along. They understood very clearly from the onset what the process would be.
So any reference to monies that they had spent throughout this process was in fact irrelevant?
I can't say it's irrelevant. I think that's a question for the developer.
In the due diligence aspects of these projects, did it go as far as determining who the beneficial owners of these companies were, or it was based on who represented either attorneys or otherwise to the investment committee?
No, the law was followed. So yes, we had to know who the beneficiary owners were.
And in this matter, it was either the attorney and or who else? You mentioned Mr. Morales as being one of the principal points of contact on behalf of Portico. Who else was coming to the table?
The persons that came before the committee were Mr. David Gegg, Mr. Gulab Sharma, and then there was also a meeting with the group that they were partnering with out of Europe, Boscales.
And those meetings would have been held with just the members of the investment subcommittee?
Those meetings were held with the members of the Cabinet Subcommittee on Investments, yes.
And just to confirm earlier, those minutes of those conversations would have been held by Beltrade?
Both by Beltrade and the investment unit within the Ministry of Economic Development.
And as chair, did you oversee the maintenance of those files and what their contents were?
Absolutely. I think I shared on the onset that I keep very copious notes. I think that I learned, as I said, very early in my career, the importance of having things clearly documented and in black and white. You know what they say, black and white does not tell a lie.
If you wouldn't mind, Honorable Panton, can I show you some black and white, please?
Certainly.
Can Can you share with this committee if you have seen that document before?
No, I have not.
Have you seen reference to that document?
No, I have not.
Have you seen that in the media?
Yes.
Okay. Can you turn to the second page? I believe there's some initials at the lower left-hand corner of those documents. Right-hand corner, sorry. You recognize any of those initials?
No.
Can you turn to the ultimate page, the signature page? Do you recognize any of the signatures on that page?
Well, it's signed and sealed, according to the document that's here, by Portugal and by the Minister responsible for Economic Development, Petroleum, Investment, Trade and Commerce.
But as your substantive minister, when you were in cabinet, you would have seen your minister's signature often. Does that resemble the signature that he would have used in other occasions?
Yes.
Personally, what you've seen in the media about this agreement, did anything strike you as bizarre, odd, strange, as it pertains to its contents? I recognize fully you have not seen the agreement in full as to what you've just said, but anything in that triggers you?
I really thought that this hearing was about determining the facts of the case. I don't know that my personal opinion should weigh in. I am here to answer matters of fact, and it is a fact, Madam Chair, that this definitive agreement did not come before me as chair of the Cabinet Subcommittee on Investment.
Thank you. Was there at any point before your demitting office instruction, directive, message, any type of encouragement, instruction at any time that a definitive agreement was not to be signed by anyone in a position to do so? Was there like a blanket note to say, look, wherever we are with this, you testified earlier as to agitation, and that it may have been happening
by Mr. Morales.
By Mr.
Certainly not
Morales.
by any member of cabinet that I am aware of, and certainly not by any member of the Cabinet Subcommittee on Investment that I am aware of. We were all clear that we were not at the stage of even negotiating a definitive agreement.
But was there ever instruction, don't think of signing anything, don't sign anything, anything in reference?
There was no definitive agreement. I don't know how many times I'm going to make the point. There was not a definitive agreement before us, so there would have been no discussion about signing or not signing. We were nowhere close to negotiating a definitive agreement. That is my recollection.
Thank you, Honorable, and we appreciate your patience as we wade through this. As you can attest that what has been in the media has indicated that certain comments, directives were made. We're just trying to determine if you, as the chair of the subcommittee at the time, did have to make a comment or a statement to say, if you are being asked to sign something, this should be your response. So that is the motive behind that question. Sorry.
In my opening statements, that I can say categorically that this did not come before me. Categorically, it did not. And there would have been no entertaining by me as the chair of the Cabinet Subcommittee if the steps and guidelines and procedures that were approved by Cabinet were not being followed. I think that we put these guidelines and procedures in place for a reason. I am a law-abiding citizen of this country, and I respect the laws of this country. There's no way I could be coerced to do or not to do if it was not in alignment with what was agreed to on how we facilitate and process investments.
Thank you. My last question, Honorable Panton, in your experience, I know you mentioned legislation required for projects valued more than $10 million. would that have been the norm insofar as every project above 10 million having legislation, or only, again, based on certain parameters?
I think what I said was that projects over 10 million US dollars were brought before the Cabinet Subcommittee on Investments. Whether or not a project required legislation would have been based on the package of benefits that would be considered by the National Assembly of Belize.
Thank you for clarifying, and we appreciate that you've gone over and beyond physically to be with us here today, and we appreciate that. We trust that if at any point in the future that the committee would like to ask you anything further, that you would also make yourself available. But we appreciate your time today. Oh, sorry, apologies. Senator Herrera? I
have one final question. You mentioned several times during your presentations that an agreement, if they reach the definitive agreement stage, that would be signed by the Attorney General or the substantive minister. For a project like this, who would be the substantive minister?
The project documents would be signed by either the Attorney General or whoever the Cabinet directs. In most cases, if it's a project, if it's a tourism project, for example, the Minister of Tourism might be directed, along with the Attorney General, to sign the documents. If it's a agricultural project, the Minister of Agriculture would be asked to help to facilitate the finalizing of these documents. In this case, the substantive minister was the Honorable Erin Contreras, who was the Minister of Economic Development, Petroleum, Investment, Trade, and Commerce.
Any other final questions, colleagues? Thank you very much, Honorable Panton. The committee will now suspend and resume its sitting at 2 p.m. Thank you very much.
Thank you as well.
I'll give to the Senate Special Select Committee touching the matters in question shall be the truth, the whole truth, and nothing but the truth, so help me God.
Good afternoon.
Afternoon, Madam Chair.
Hopefully we have resolved the technical issues that you will not have to be turning on and off the mic, but we'll
Okay.
go with that.
So I just leave it on?
Yes.
Okay.
Thank you for affording us your time. I'd like to offer you an opportunity to make an opening statement to the committee, if you so wish.
Madam Chair, if I may say, you don't need to thank me for my time. I believe when the upper chamber wants your presence, you should be here. And it is not a waste of taxpayers' money. And I want to open by saying, Madam Chair, that indeed, inquiries like this shouldn't be necessary. We have a set of laws under the Freedom of Information Act that all of this information should be free-flowing from any responsible government. So when this one turns out to also be expensive, I hope the government can take responsibility for making sure we have an unnecessary Senate inquiry. Madam Chair, as it relates to this matter, let me read to you something, with your permission, a letter of which I'll give you a copy afterwards if you so desire. On March 4th of this year, 2023, I wrote a letter to the Prime Minister of this country. I said, "Dear sir, it has come to my attention that the likelihood of the existence of a definitive agreement between the government of Belize and Port of Magic Belize Portico, an outfit spearheaded by Mr. David Gegg, is very high. It has also recently come to my attention that that purported agreement was signed by a minister more or less a month before the last general elections. On the news, you said that you have not seen the signed agreement, as I have not as well, but that the Attorney General, then Honorable Magali Marin, would look at the document to determine its legality. Pursuant to the Freedom of Information Act, Chapter 13 of the Laws of Belize, I request from you the following. 1, please verify for me that the agreement, signed and executed, does exist. 2, please provide me with a copy of the agreement if it does exist. Needless to say, this letter to this date has not been answered by the Prime Minister. And had he answered this letter back in March of 2023, the public would have had the information it needed, and we don't have to indeed take up valuable time with such an inquiry. Subsequent to that, there was a cabinet meeting. And subsequent to the cabinet meeting, I wrote to the Prime Minister again, because he said he gave legal advice. I said, Prime Minister, on July 10th, the proverbial stuff don't hit the fan already. It has come out that the Prime Minister has accepted that Portico has invested $11.5 million with no proof, a company with 200 shares bought up with 2 individuals each. I don't know how they spend $11.5 million. And the fact that the government was supporting a document that they claimed was illegal with matching legislation behind it, ready to come to Parliament. All of that unnecessary had the Prime Minister just followed the law under the Freedom of Information Act. On July 10th, I wrote to the Prime Minister again when I realized that our government hired people who charge 2,000, 3,000 US dollars an hour. Not as much as you see in a council, but close. I said to Prime Minister July 10th, your government retained 4 attorneys, namely Ben Juratowicz, Callista Harris, Douglas Mendes, and Jerome Rajkumar, to advise whether the definitive agreement signed in October 2020 between the then Minister Contreras and Portico Enterprises is binding on the government of Belize. On April 20, 2023, Juratowicz and Harris delivered their joint opinion, and on May 4, 2023, Mendes and Rajkumar delivered their joint opinion on Juratowicz's opinion. So there was monies paid for an opinion, and then there was monies paid for an opinion on the opinion. All of that Cabinet had before it when they took that matter to Cabinet for a decision. Pursuant to the Freedom of Information Act, Prime Minister, I now ask you as the Minister of Finance to please inform me of the cost of those opinions. To this date, no answer has been given to this letter. On August 9th, 2023, I made a final appeal to the Prime Minister to answer my questions. Madam Chair, the public sentiment out there is that these inquiries are a waste of taxpayers' monies and nothing will come of it. I want to say that I want you to make a difference in that arena, and I want to say, and the public to understand and appreciate, that we are about to expend monies on a necessary process because we have an irresponsible Prime Minister who believes he doesn't need to answer anybody when it comes to the public monies. These are documentation I have, and then there's one more piece of documentation I have, Madam Chair. I heard you ask Honorable Panton about it this morning. It was an email. It was in the middle of June. You were in the National Assembly, and the Prime Minister, in dramatic fashion, got up and tear up something. The definitive agreement is too thick for him to tear up like that, but he tear up something. And then he said he has here an email that was sent to Michael Perifeet. Michael Perifeet said, never know about no definitive agreement. Here I have an email to show you. Well, the email that he was waving in Parliament was an email that was addressed to the Honorable Panton, not to me. So I just wanted to and I'll give you a copy of that email, Madam Chair, along with the correspondences that I have read. And with that, Madam Chair, I'm in your hands.
Thank you for that opening statement. Could we start a little further back? Can you describe to this committee your role under the period in question, 2015, 2020? What was your role with
from 2015 to January 2017, I was the Speaker of the House of Representatives. From January 1st, 2017 to November 2020, I was the Attorney General and Minister for National Security.
As a part of your role as the Attorney General, could you describe what your core functions were, so to speak, in terms of what was your day-to-day?
Well, it's defined as the government's principal legal officer. We represent the government in terms of the government suing or the government being sued, and we give legal advice to the government and represent the government in all legal matters, and different ministries as well. So if a particular ministry would want advice on an issue within their ministry, they would write to us, we would advise them, and we would give them our opinion.
And would that have included signing documents, entering into contracts?
Well, usually what happens is we only advise the ministries. And once we advise the ministries, we would give our opinions in writing, and then most of the time, the various ministries would have their CEO or their minister sign. Every now and again, to signify or to satisfy people who enter into big contracts with the government, Cabinet would from time to time instruct that different ministers sign different contracts, and as the Attorney General, whose ministry would normally be the one to prepare those documents, I am usually directed to sign. So from time to time, I would be directed to sign, like I was directed to sign the State Bank Enterprise definitive agreement for the government along with the Honorable Tracy Panton.
Directed by whom?
By Cabinet.
And when you say prepare from scratch, or there was a template, or private attorneys prepared something, how did that work?
It worked in different forms, but mostly the government would be the one to prepare the contract. Because usually 99% of what you do in law has been done before. So we always had the templates and the precedents, and we would more often than not be the ones to prepare. But there are times when private enterprises would prepare a document, we would look at it, and we would go from there, and if we either adopt it or adjust it in whatever way, shape, or form, then we would do that, but that rarely ever happens.
Was there any protocol in terms of when, where, and how agreements were entered into? Was it in the presence of the Attorney General when the Attorney General wasn't signing it? Was it done in particular places, locations?
Well,
how was that handled?
It would depend. I mean, if it's a big project, you would have the media, you would have different things, but on a regular basis, you sign rental agreements for housing, rental agreements for supplies, and it's not every one of those the Attorney General Ministry is present for.
Contracts worth 10 million US or more, where were those handled as a norm?
Well, those were handled with the Subcommittee on Investment, and we would only sign those contracts upon the direction of Cabinet.
So as a part of your function, you were also legal counsel advisor to the investment subcommittee? Well,
yes. I played a dual role. I was there with an investment cap on, and then it was easy for the panel to say, well, is this legal? Is this not legal? I mean, what is the legal basis for this or that? And since I'm already there, they would just put that on me. I would take it to the ministry. They would do their research, advise me, and then I would advise the investment committee on the legality of anything that we may want to agree on.
And to your recollection, who was in those meetings, either as members of the subcommittee or visitors or invited guests?
Which meeting?
The investment subcommittee meetings. We heard earlier that sometimes you met as often as once a month.
Yeah, well, you had the chair.
Who was attending?
You had the chair, who was Honorable Tracy Panton. You had the Deputy Prime Minister at the time, Honorable Patrick Farber, Minister House, myself, Minister Heredia, and Minister Pat.
As regulars?
As regulars, yeah, that was the committee. Of course, not all the time all of us attended. We would send an alternate, or there would be enough people there to form a quorum.
Okay. Do you remember any other alternates by name that would appear on behalf of other regular committee members?
No, I'm sure that you have the minutes of the meeting. Just check the minutes and you'll see it there.
Okay.
I know sometimes, I think once or twice, if I'm not mistaken, the Solicitor General appeared on my behalf, if I'm not mistaken.
Okay. This was your core function as a government, as a member of the government. You also had professional interests in other lines of work, in business. You had your own.
Well, I had a law firm, but as the good former Attorney General himself will tell you, there is a law. Unfortunately, not everybody follows the law, like not everybody filed their returns every year with the Integrity Commission. But there is a law that I follow and followed. Once you become a government minister, you must divest yourself completely from any firm that you belong to. The law even states that the letterhead of that, or of any letter, anything coming from that law firm, while it may have a business name, your name is not allowed to be on the letterhead as a person working in that firm. So the minute you become a government minister, especially if you're an attorney, there are specific rules as to what attorneys should do. And the main rule which captures everything is that you cannot be a member of that law firm. You cannot go there, you cannot work there, you cannot participate in any activity or decision making of that law firm. It is a conflict of interest, and I followed it strictly.
And that covers formal and informal communications?
Well, yes, it does. It does.
And divest means you are no longer a beneficiary owner. If that firm gets payment, you don't get
It
any?
depends. It depends. You can come to agreement with your partners as to what you will benefit from. You can say to your partner, look, such and such is bringing in such and such. Do you want to be associated with that? And you can say, no, I refuse to draw shares for that account. You can do that.
On a case-by-case basis?
Of course you can.
When did you learn that your former firm had been retained by certain investors, and was this the only matter that this overlap happened?
If you look, as far as I'm aware, yes. If you look at the letter that I will give to you in June, it's dated June 1st. I think it was 2020. The one that member for Albert Panton said that Morales sent to her. It was around a couple weeks before that. David Morales telephoned me and said that he has been retained by Portico and that he wants a definitive agreement to be signed that he has. I told him, we cannot be talking about this. He knows better than that. Secondly, I told him, our communication go directly to the chairperson of the committee. They don't come to any other member naturally. If you want the committee to consider something, send it to the chair. And that thirdly, I did say to him, but did I miss something? Because as far as I know, we're not at the definitive agreement stage with that particular project. I know that there has been no indication that the principals could have the financing for the project. I know that there's been no indication that there was a discussion on the land ownership as to where the project would be. And I know that thirdly, there was no environmental clearance yet for that project, all of which you have to have before you reach a definitive statement, a definitive agreement. So I said, one, I am not allowed to sign it because you can only sign it after cabinet directs. But don't let me stop you. From now on, all communication with this project, do not communicate with me. Don't do it. Communicate directly with the chair. And he said, oh, all right. He didn't seem to mean anything bad by initiating the call. But being aware of these things, I said to him, that is what you should do. And I guess based on that email, he proceeded then to send the definitive agreement to the Honorable Tracy Panton directly to her email.
So let's take a step back. You referenced that you signed the agreement for Stake Bank. Can you walk us through what would have been the stages associated to that, or what led to that, so that you ended up signing that?
Well, you reach a memorandum of agreement, and when you're done with the memorandum of agreement, and you're thinking about doing a definitive agreement, which is more specific, the memorandum of understanding, is not an agreement per se. It is just an indication by the government that the government is interested in exploring the project. When you reach to the definitive agreement stage, then you are saying that yes, the government not only is interested in exploring this project, but you are going to do this project. And for Stake Bank, they went through all the stages that they needed to go through, satisfied the committee of all the things that they needed to do, and when it reached Cabinet, Cabinet said, after having a report from the subcommittee, that Stake Bank, having followed all the instructions of Beltrade, all the requirements of the investment committee, that they deserve a definitive agreement between themselves and the government. There is a proposed piece of legislation that then has to be drafted, which our ministry drafted. We came to the National Assembly, passed that law, and that is how the definitive agreement came about for Stake Bank.
And roughly, do you remember offhand how much time we're talking about between when that MOU was signed and when they ended up with their definitive agreement?
Oh, I'm not sure. You would have to check with the minister. But it wasn't a couple of weeks or a couple of months. There's a lot that has to happen between the MOU and the definitive agreement.
Can I show you a copy of a document and have you look at that? You shared just now that you were aware that there was interest because of that call from your former law partner, that there was interest in having a definitive agreement signed.
Yes.
When did you come to know that one existed or may exist, and how does that?
It was in, I think, February of this year. I was in a meeting with some foreign investors, and one of them brought up the concept of cruise tourism. And one of the people in the meeting indicated to me that they had some association with Royal Caribbean, and that Royal Caribbean would be doing business in Belize with Portico. That's what I was told. I said, that's interesting, because as far as I know, the government has entered into only what we call a memorandum of understanding. This was in February of this year. And the person told me, no. They believe that Royal Caribbean has a signed, sealed agreement with Portico because Portico has a definitive agreement with the government of Belize. I was shocked and horrified, actually, because I said, when did this occur? This is what led to my letter to the Prime Minister in March. So, Prime Minister, I heard that there is one. Give it to me. Let me see it, because I'm interested to know how that came about.
So at no point between 2017 and October 2020, you had any side knowledge of any iteration of that version of that agreement?
No, because when I got the call from Morales, I told him that whatever he wants to send to the committee, send directly to the chair. Don't send anything to me. The first time I saw this definitive agreement was right after there was an apparent supposed mutiny in cabinet on May 15, 2023.
Okay.
I saw this document a couple of days after May 15, 2023, when the government tried to have cabinet ratify this agreement with legislation to match. That's when I first saw this agreement.
In your council as Attorney General, and we are aware of certain court action that had been taken up against the government in terms of exclusivity.
Yes.
And that not being something that the government should be doing. I think there was a successful court case that removed any exclusivity rights held, I think, by one company at the time.
Yeah, I think so.
And then there was a request, we understand, for that to come back onto the table, exclusivity for cruise operations. And then was there a position taken that irrespective of anything such as economic feasibility or environmental impact or otherwise, that it would not be, the projects would be considered independently as opposed to?
Well, as far as I remember, the Prime Minister, and it's rubbish, by the way, that you can't discuss things that happen in cabinet. It's rubbish. The people's business is not private business. The people's business is public business. Whenever we discussed this in cabinet, the then Prime Minister made it very clear in cabinet, as he did in public, that the court indeed had said something about exclusivity, and that no one port should have exclusivity per se. There, of course, have been discussions about what he meant by exclusivity, whether it was exclusivity in the collecting of taxes or exclusivity in the existence of cruise ports within a certain radius. But yes, the topic of exclusivity was always front and center.
In your capacity as AG and in your role as advisor to the investment subcommittee for the previous cabinet, what documents, policies, any terms did you advise them with? Was there a cruise tourism policy? Was there a national agenda for development?
As far as, no, I wasn't aware that it was a formal cruise tourism policy. I know that every year or every so often the BTB would give a report as to what is their overall, but a specific cruise tourism policy, I wasn't aware of one. And the investment committee was not concerned with exclusivity per se, and that is why you have the backstop of the bigger cabinet. The investment committee was concerned with, we had 5 core things, I think, 5 or 6, I'm not sure. Is it environmentally sustainable? Is it going to bring in foreign exchange? Stuff like that. The whole concept of whether or not we could legally enter into a definitive agreement, for example, giving exclusivity to a particular entity, that would solely be then the job of the full cabinet, and then I would wear my hat purely as Attorney General at that point. But it was never the position of the then government that there had to be exclusivity for cruise ports.
And ordinarily, you're saying that once there was agreement that we're at the definitive agreement stage, it would have gone to the main cabinet, and then what would have happened?
No.
What would have been
What
the
would
process?
happen is that you have an MOU. It doesn't reach the definitive stage agreement before cabinet. Cabinet determines when it's at the definitive stage. So you would have an MOU, and based on that MOU, the ministry, the government spearheaded by Beltrade and the Ministry of Investment would then put certain tasks to the developer. Now that we have an understanding as to what you want to do, and know that we are interested in this project, for example, these are the things that you must execute. Once they execute, then we report to cabinet the MOU position, we report to cabinet what all we expect from them before we even think about definitive agreement. And then, once you report that back to cabinet that yes, after the MOU we require these 10 things of these people, they have satisfied these 10 things. What is the position of cabinet? Cabinet would then say, well, they haven't satisfied the 10 things, then we're not doing a definitive agreement. Or they have satisfied these 10 things, let's prepare a definitive agreement. Mr. Attorney General, instruct your ministry to prepare a definitive agreement to reflect this project. That's how it would happen. Then once the definitive agreement is prepared, I then do a cabinet paper submitting the definitive agreement, just like what this government did in May 15, 2023, just like what they did. We would submit the position of the government along with possibly at that time draft legislation to say, look, we think that this should be the definitive agreement. Cabinet then studies it, determines if they want to change anything or put anything in there, and then once cabinet has a document that it's satisfied with, we contact the relevant parties and we set up for a signing.
To your memory, was every contract that or agreement or document that was signed between the government and another entity that was legally binding, you had some witness or knowledge of that signing, awareness of it as the chief legal person?
Every government, every contract that affected the government nationally, like for example, if the Ministry of Works wants to put out a tender for sand, that doesn't necessarily come to the EAG's ministry unless the Ministry of Works wants advice on the contract.
No, we're talking substantive matters, 10 million US plus, matters before the investment
at that level,
committee.
it would come to cabinet. And at that cabinet level, then the government and the cabinet would want the EAG's ministry to be involved.
So were you ever aware at any point that a minister had independently signed something and you were made aware of it after the fact?
I became aware of that after the definitive agreement was leaked
So that was the
to
only
the
instance?
public. That was the only incident that I'm aware of, that a minister signed something against an established protocol of cabinet. Because when it came to these investments and to this definitive agreement situation, cabinet had a strict protocol. You have an MOU, these people then get things that they have to do, they do it, cabinet then says, yes, let's prepare a definitive agreement. It comes back to cabinet, cabinet sanctions that definitive agreement, and then cabinet instructs. You two ministers go and sign this document with this particular entity. That's how it worked when it came to matters from the investment committee. The investment committee was not empowered, and neither did we try to exert any power that was not given to us by cabinet. And we made it very clear to everybody. The investment committee, nor any member of the investment committee could agree or sign any agreement with anybody except with the express permission and direction of cabinet.
And that was a directive and instruction? How was that conveyed?
Yes, that we discussed that all the time. I mean, when I first became a member of the committee, all of the terms and reference were explained to me on what we are doing here. And the cabinet's position, the policy of the government was the investment committee really is an exploratory committee that goes and finds out the viability of these projects. And then they would report to cabinet, and cabinet would always have the final say. No member of the investment committee had the authority to sign an agreement on behalf of the government without the express permission of cabinet.
So is it your testimony then that no member of the former administration can come and say that they were instructed to sign any such document?
Instructed by who?
Well, that is the question.
They could say that they were instructed by cabinet, but then the cabinet minutes would show whether or not they were. But I am telling you, I'm not aware that any cabinet that I sat in instructed that this definitive agreement that we have here, the document that you just showed me, no cabinet that I sat in instructed that this be signed. None. Not even the investment committee approved that definitive agreement because it never came before us.
I will yield my time to my colleagues for questioning, and I will resume subsequent. I acknowledge Senator Bishop Alvin Bengushe.
Thank you very much, Mr. Perafit. It is very informative to have you this afternoon sharing in this committee proceedings. And I'm happy to hear in your opening statement how seriously you take the work of this committee, also insisting that that which has been put aside for this work is not a joke, nor is it a waste of time. And I share those sentiments as you have expressed them. Allow me, perhaps in a part of what you have shared so far, and I hope I'm not misquoting you. You indicated the people's business is public business. And I asked this question, I tried quoting you, based on a question that I asked this morning. And let me just perhaps share the question again, as I shared it this morning. Under your previous the administration you were part of, as a cabinet minister, was it a given that cabinet details could not be shared with the Belizean public?
No.
Thank you. May I follow up, Madam Chair? And I'm happy that you made reference to the Information Act and that which you have also followed up with correspondence to the present Prime Minister, asking for some information. You have indicated that that information is not forthcoming. Am I correct?
You're correct, sir.
And having said that, Honorable Perifeet, may I also ask, perhaps, as you were a part of the cabinet, the former cabinet, insofar as the investment committee is concerned or any potential for investment within the country, you said that it was discussed by the subcommittee, which was then, as it is advanced, taken to cabinet.
Correct.
And then cabinet would so advise.
Correct.
May I ask, what, if any, was the role of the former Prime Minister in his capacity as head of the cabinet?
What was his role?
Yes, what was his role insofar as any advancement of investment was concerned?
He played no role.
He played no role.
Because he would, from time to time, Senator, you're in government, people come to you as ministers, as senators, as area reps, asking you all kinds of questions. And as a responsible public servant, what you are obligated to do, in my view, if I'm the Attorney General of a country, and somebody says, Mike, how do I do ABC? I would say, listen, if you want that, you need to apply over there. They have their process. Various times, people would approach different ministers with investment ideas and projects. And the Prime Minister at the time did the same thing that we all did. But then take your application to the investment committee. That there's a process to vet all of those. Whenever the investment committee had a report to make to cabinet, or the cabinet had to make a decision on any position that the investment committee was proposing, or any decision that the cabinet had to make, the Prime Minister acted as no more than just another minister. Because at times we would vote. We would say, what do you think? How many of you think? So there was no scene where the Prime Minister would facilitate some investment that would circumvent the subcommittee. Absolutely not.
May I, Madam Chair? As I said, there are two correspondents to the present Prime Minister.
Yes.
Is that you're asking for some information as it pertains to the MOU.
No, it was as it pertains to the definitive agreement.
As it pertains to
I was fully aware of an MOU. The MOU, sorry, Senator, the MOU for Portico did come to cabinet. And the majority of cabinet said, yes, let's proceed with an MOU because it's non-binding and it's exploratory at best.
If I may ask, and I ask the previous question, what, if any, role the former Prime Minister played? Would you, in your estimation, perhaps, in my own words, perhaps say that at present, as this situation is at the present moment, that perhaps the present Prime Minister would not, in a sense, be playing the role as the former Prime Minister insofar as being a member of the cabinet and having that one vote within the cabinet?
Senator, with the maximum respect to the office that that gentleman holds, the current Prime Minister cannot carry the briefcase of the former Prime Minister. They don't match up at all. The former Prime Minister, if asked a question, whether in Parliament, freedom of information, I would say would have answered. Because there's nothing to hide. It's public information. If I ask you, if you're a Prime Minister, Senator, and I ask you, is there a definitive agreement? What is the harm in you saying, yes, there's one, here it is? If you use public monies, Senator, to pay attorneys from taxpayers' money, and I ask you, how much did you pay them? It shouldn't be a secret as to how much you paid them. And so if you cannot be forthcoming with that information, which is simple information, then what other important information are you not forthcoming with? That may be far more important, with far more far-reaching consequences. And I believe that when, I don't like to refer to myself in the third person, senator, but when a senator writes to a prime minister asking for information respectfully under the law, and that prime minister doesn't provide it, there's something wrong with that prime minister. If a prime minister can look at a Senate committee that we are comprised of right now, and we're engaged in this activity, and say, I don't see why you need to call me. Like he is above this, like this is beneath him. I don't think that's a good prime minister. That's just my opinion.
Thank you very much. I yield.
Senator Herrera.
Senator Perfit, on the matter of transparency, we note that in clause 33.1 of the document, I think that was presented.
The definitive agreement?
Yes.
33.1.
That there seems to be, there's a confidential clause. From the testimony this morning, the person, Senator Honorable Panton, said that that might not be an unusual clause, that it may exist in other agreements as well. Would you be able to tell us why a clause like that would be in a contract such as that, when really it should be public information?
I'm at a loss, Senator Herrera. I cannot understand. If you read 33.1, it's practically, or 33.1, it's fierce, man. No party shall issue or make any public. This is 33.1 of the definitive agreement that this government wanted to pass this CMA, that they endorsed this CMA. No party shall issue or make any public announcement or disclose any information regarding this agreement unless prior to such public announcement or disclosure, it furnishes the other party with a copy of such announcement or information and obtains the approval of such persons to its terms. However, now if you stop right there, Senator Herrera, what this is saying is that if as a citizen, tax-paying citizen of this country, ask the government for this document, this PUP government wanted to be that first they have to get Portugal's permission to show anybody this document. No, that is beyond insulting, because then you cannot put anything in there that violates the law. They try to correct it by saying, however, no party shall be prohibited from issuing or making any such public announcements or disclosing such information if it is necessary to do so to comply with any applicable law or the regulations of a recognized stock exchange. You're a better businessman than I am. If something is being publicly traded, then the information about that company cannot be secret. If people are buying shares from the public, or disclosing such information if it is necessary to do so, that could not use this section to say that he couldn't give me the document, because the applicable law is the Freedom of Information Act. This is not a dictatorship, this is not communism. This is a representative democracy, and the people have a right to be informed.
Are you saying that this is a highly unusual clause?
I would say the first sentence is highly unusual.
Would you say that it's highly unusual to have a confidential clause like this in an agreement such as this?
Yes, and I'll tell you what for me makes the difference. It is highly unusual to say that nobody can talk about an agreement when it is not a private agreement. In my view, assuming that cabinet had approved this, our cabinet had approved this, you cannot tell the people that information cannot be given to the people. But I would say, though, that there is a however, Senator Herrera. That however tells you that you can't make nothing public, but if a law says you have to make it public, then you have to make it public. But I think such a confidential agreement like this shouldn't be necessary, because under our Freedom of Information Act, something that the people of Belize do not employ often enough, nothing is secret. One particular Court of Appeal judge for Belize said when in the previous PUP administration, we had all these confidential agreements, and the Court of Appeal judge looked at the government and said, what is contained in these agreements? Nuclear weapon secrets? Because that's the only thing that could be confidential. I could understand, and in the Freedom of Information Act, there are exceptions for military, for police, and stuff like that. For national security purposes. You're not going to relate to the public where the BDF are going to set up to defend the country. You're not going to do that. But a document, an agreement, a business agreement, a commercial agreement, that can't be secret in my view.
Thanks. Was the Norwegian cruise line definitive agreement signed while you were Attorney General?
I don't think so. I think when I became Attorney General, it was already signed.
Was Belize Island Holdings Limited definitive agreement signed?
No. I would have to see the date. We did a lot of documents and a lot of agreements. The only one I remember coming from the investment committee that reached the definitive stage was the State Bank definitive agreement.
Would you be able to say whether or not State Bank definitive agreement had a confidentiality clause in there?
I would have to see. I don't remember the document verbatim. I would have to see. Did
any of the investors meet with you? Any of the principals behind the Portico investment, did any of those meet with you in your capacity as Attorney General?
What you mean, the principals behind Portico?
The Portico investment.
Okay, you mean Mr. Gegg? So
yes,
David Gegg?
And I think there's another gentleman as well.
Several times, the investment committee had meetings where they would make presentations to the investment committee. Those times when Mr. Gegg or Mr. Finstein or any other person wanting the support of the investment committee would meet with the investment committee openly like this for an entire day sometimes. Those were the only times we met. At no time I was a member of that investment committee did I ever meet with any prospective developer outside of the investment committee. At no time.
Was there any discussion in those meetings with the investment committee when you met with those individuals? Were there any discussions with respect to exemption from taxation, duties? Did you get into any of that type of detail at those meetings?
We weren't there yet. We weren't there yet. When it came to Portico, all we had was a memorandum of understanding. You get into those discussions when you have a definitive agreement position and you're prepared to do a definitive agreement. And then this is where the AG's ministry would advise as to, even if it is the policy of the government to grant certain exemptions, the Attorney General's ministry's job is to advise the cabinet and the government as to what it is allowed to give an exemption on. Because there are certain exemptions that not even the Minister of Finance can give. There are certain exemptions that can only be given by the passage of a law at the National Assembly. And you look at this definitive agreement, there are exemptions in here that cannot even be granted by the Minister of Finance.
In your view, the exemptions that are contained in that document, are they unusual based
Some
on
of
what
them
you've
are
seen in other
extremely
agreements?
unusual. There are some that exempt you from getting central bank approval for financing. You pretty much are to have free access to foreign currency with no check and balance. It goes as far as to nearly say you could open a bank for yourself. There were certain stipulations in this definitive agreement that were just simply mind-blowing.
Senator Cowell?
Good afternoon again, Senator Perfit. I have a few questions to ask. Earlier you mentioned about an email sent to Honorable Panton. When did you become aware of that email?
In the news.
When and what date?
Oh, the day, the hour, the time, the second, I'm not aware. But Senator, you look at the day of the House meeting where the Prime Minister tore it up and said that this is the email. That's when I became aware that David Morales had sent that email purportedly with the definitive agreement attached to Ministry of Investment, Trade and Commerce.
And
I was never aware of that email before that day.
Just for clarity, can you repeat again when you became aware of a definitive agreement?
A definitive agreement?
A definitive agreement,
Well,
yes.
I guess you could say that sometime in May 2020, I knew that probably there was one because I got a call around May 2020 asking me if I could sign one. So I guess one existed.
Okay.
I am supposing that when the email was sent to Minister Panton at the time, that one was attached to it. I'm supposing that. But I became aware that one was signed this year, May 2023, because I had asked the Prime Minister in March if one was signed and if he could give me a copy, and he refused.
Is it not at your best interest then that you know there was one circulating? Because I was going to refer you to some interviews that you did with Channel 7, but you just confirmed.
Sorry, Senator, you're not being clear. I didn't hear you clearly, sir.
Yeah, so what I was saying is that you just said earlier that there might have been an attachment of a definitive agreement back, and you heard that there was one in May, but hasn't been signed, right?
No. I said that possibly there was one floating around in May or so of 2020, because that's when I got the call from Mr. Morales. And let me say this as well. It wasn't some clandestine smoky room kind of call, like, boy, no, it wasn't like that. It was a genuine, I have a definitive agreement I want this. I said, no, it doesn't work like that. So I was aware that he had one. He sent it, obviously, to Honorable Panton. In February or January of this year, I heard through a business meeting that I had that there was a definitive agreement that was signed.
Yeah.
That's the first time I heard that there was not just one trying to be signed, there was one that was signed. Immediately then, I wrote to the Prime Minister. Send it to me. Is it true that one is signed? Because I wasn't aware of that. And if you have it, please give me a copy. That was the purpose of my March 4th, 2023 letter.
Was it not in your best interest then, as it was earlier this year, for you to really find out as the Attorney General of an agreement?
You mean when I got the call?
Yes, when you got the call. So you just ignored it and didn't worry if there was an agreement?
Listen to me, Senator. The amount of foolishness you get approached with when you're in government, you have to have some patience. So what you do is this. You don't want to be rude. You don't want to be disrespectful to anybody who wants to make any submission to government, no matter how ridiculous it may be.
Right.
After saying what I said to Mr. Morales on the phone, I told him, don't let me stop you. If you believe you want to send a document to the government, send it, feel free. Because I knew in my mind that there was a high likelihood that the chairperson would not even submit that for conversation, because we were not at the definitive agreement stage.
Just 1 second. In a letter sent to you by David Gegg on February 22nd, he's David Gegg.
Yes.
So that was in the media. So he went on to say that.
Which were part of the letter? I have the letter. Where went the letter?
Yeah. So he went on to say that he went on to say that the
Which
email
part
was
of the
sent to
letter?
you on Honorable Panton.
Where's the letter?
So I was just quoting from a media interview that was
No,
done.
but what part of the letter he said he emailed me? I have the letter here. Okay, it's the fifth paragraph where it says, by email dated 1st of June,
Yes.
2020, Morales Perefin sent you. Well, I have the
The
letter
AJ.
here. I have the letter here. Clerk, you could show the chair, or maybe if I could show him. Where in there he sent me? One
Yeah,
email was sent to Tracy Panton, to the Honorable Chair. None was sent to me,
Can
sir.
you do you have any indication of what the email entailed?
What the email entailed?
Yes.
It's right there. The Prime Minister distributed it after he waved it around in the National Assembly. The email is clearly addressed to ITC, which is Investment, Trade and Commerce. In his email, in his letter to me, he said that he sent an email to me and to Tracy Panton, which is untrue.
For the record, can you please read the email
Yes,
to the
sir.
committee?
Yes, 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 yes. He said, good day, Minister.
Can you just state the date of the email, please?
The date of the email is the 1st of June 2020 at 5 p.m. Subject, definitive agreement, Portico Enterprise. The email address is to minister@itc.gov.bz. That's it.
Can
No
you
other
clarify
person.
who that email belongs to?
That is Investment, Trade and Commerce. It certainly wasn't the AG Ministry's email. And then he says, good day, Minister. I trust you have been keeping safe. I've been instructed by David Gegg to forward the attached document. Will you be grateful were you to acknowledge receipt of this email? Have a good evening. Kind regards, David Morales.
Does the email have an attachment?
It looks like it does.
Can it be opened?
No. All I have is a copy of the letter that the Prime Minister had in Parliament.
Okay.
The Prime Minister did not produce in Parliament what was the attachment to the email. I don't know. That email was not sent to me. I even asked David Morales, subsequent to that coming out, did you send me an email? Because if you sent me one, no problem. It's neither here nor there. I didn't read it. I didn't look at it. And even he confirmed to me, no, I did not send it to you. I only sent it to Tracy Panton.
Thank you very much.
Senator Bennett Moody.
Good afternoon, Honorable Parfy.
Afternoon, Senator.
Thank you for being here.
Welcome.
You had served on the Cabinet Subcommittee for Investment during your time in office. Can you state for how long that term was?
From the moment I became Attorney General, that was one of the committees I was assigned to almost immediately.
Can you state the year?
Well, I became Attorney General, as I said before, January 2017. And I no longer became a member of the committee after the change of government in November 2020.
Thank you. Can you describe for us, the committee and for the nation, how decision-making is made at the cabinet level?
At the cabinet level or at the committee level?
At the cabinet level.
The way let's just say, for example, someone wants to invest to build an airport in Belize. They submit their proposal to the subcommittee via Beltrade, or the Ministry of Trade and Investment. Or they may give it to any member of the subcommittee, who then forwards it to the investment committee. The chair would then table that matter for discussion, and we would look at our terms of reference to see if the proposal satisfies certain things for us. Environmentally friendly, foreign exchange, employment, etc., etc. We would then look at a number of different things. For example, sitting there as an attorney on the board, they want to come and set up a marijuana dispensation plant. It will be my responsibility to say, it sounds good, it will bring foreign exchange, it will do all of that, but it's not legal. And we would have a discussion on all of that. Essentially what we'll be doing is filtering, because there were some projects that were rejected right away. That's foolishness. That could never fly. There were some that required further explanation, but the ones that passed the first test, that we think the government would have an interest in based on our policies. We would then, or the Minister for Trade then, would prepare a cabinet paper and say, look, we had an interest from this enterprise. We believe that it could qualify or provide all of the different things that we wanted to provide, and we think that we should enter into a memorandum of understanding with them to let them know that we're interested in the project. Once that happens...
Sorry, sir. So a memorandum of understanding is established at the cabinet level? Because my question is, how is decision-making made in the cabinet?
Right, that's what I'm telling you.
All
the investment committee makes no decision. The investment committee only says, based on the terms and reference given to us by cabinet, they pass muster. Once they pass muster, we tell cabinet, this particular project ticks all the boxes that we require them to tick at the first stage. Cabinet would then say, okay, if that is the case, cabinet discuss it again. Sometimes some members of cabinet would say, I want to read more on it. I want to know more about it. I want to learn more. But eventually you would come back and you say, okay, let's enter into a memorandum of understanding with these people. You explain to them, it's not binding. The government is not committing to anything. The government is just interested in exploring the possibility of engaging in this enterprise. You get a cabinet then says, Mr. Attorney General, draft an MOU, please, and put it there, and then bring back that MOU to cabinet for cabinet to review and decide whether or not this is an MOU they want to enter into. And that's when you're at the MOU stage.
All right, so for clarity, when cabinet gives that direction or that directive to the Attorney General, is that a decision made by majority, or can just solely the Prime Minister gives that directive to AG?
That's not how Prime Minister Barrow ran his cabinet.
Not making specific reference to either Prime Minister, I'm just asking for the process.
Well, I'm telling you that it was by the majority or a discussion, or as a responsible Prime Minister, what he will do is that if he sees that half of us are with something, half of us are not with it, he may say, listen, let's not argue all day here over this one issue. Let's defer this paper, have a discussion, and maybe you can come to some sort of consensus or agreement or whatever. And you would find sometimes that people switch their positions, or people agree with other people, and there were times when the Prime Minister himself, his position was rejected. And then you would go back and you would do a reassessment until finally there was some sort of consensus, which he liked. He liked to have the feeling that, you know what, there seems to be general consensus that this is what we should do. And usually when we reach that stage, then he would direct me to do an MOU or whatever is needed for cabinet to get done.
Thank you. Moving along in terms of my line of questioning, the document that you have before you right now that was served to you today,
The definitive agreement.
the definitive agreement by and between the government of
Yes.
Belize. Could you state the date on that document?
From my memory of this document, there doesn't seem to be, well, it says here 1st of October 2020.
2020. Can you state for us, for the record, which signatures are assigned to this document?
Well, it looks to me, like that's Erwin Contreras' signature to the right,
Okay.
but Minister Panton will be more familiar with his signature than I am, but it looks like it. There is one where it says there, he says Erwin Contreras printed, and then there's a witness. I don't know who that witness is.
Do you see a stamp with the name Honorable Erwin Contreras, Minister of Economic Development, Petroleum, Investment, Trade, and Commerce?
Yes.
Okay.
I also see one for Portico Enterprise, and the signatures, there's a signature of a director to the top. I don't recognize that signature. The director in the middle, I don't know. It looks like it says Gulab Sharma, but I'm not sure of his signature either.
Okay.
And the third signature, I'm not aware of who that person is. I don't recognize that signature.
All right, thank you. Can you say from your recollection if this document was brought before you as a member of the Cabinet Committee for Investment?
No, it was not.
Can you state the position and role of Mr. Erwin Contreras during your time of office?
As far as while certainly his ministry was the one spearheading, and I acted as a secretariat and the point of contact for the investment committee, Minister Contreras was not a part of the investment committee.
Okay, could you share with us what his position was during your time in tenure for government?
He was the substantive minister to Minister Panton, who was the minister of state.
Okay. Could you share with us when did what term or what date the last administration ended?
It's a date that I don't like to remember, Senator. But I
For
think
the
it may be
record.
November 5th, 2020, I think.
Okay.
November 5th? Yeah, November 11th, sorry. See, I don't like to
Okay.
remember that date.
Thank you. Can you recall if there is any matching legislation to this document that is before you right now?
I am aware that in the cabinet meeting of May 15th, this government tried to pass matching legislation for this agreement. Yes, but there was no legislation for this agreement during our time, or whilst I was Attorney General.
All right. At 2:25 p.m. this afternoon, you made a statement to say that Morales sent the definitive agreement to Tracy Panton. If a definitive agreement was not before the cabinet subcommittee for investment, which definitive agreement are you referring to that was sent from Morales to Tracy Panton?
Well, I don't know. I never saw the attachment to the email that he sent. I'm only assuming that he sent a definitive agreement relating to Portico, but I never actually saw it. And from the email that he sent to the Honorable Panton, I have not had custody of that email with the attachment to that email. The only definitive agreement I have is the one that this cabinet tried to pass on May 15, 2023.
So is that to indicate to us as a committee that you would have knowledge thus far of two definitive agreements as it relates to Portico?
I don't
One
know.
signed by Erwin Contreras and one that you are stating has been proposed by the present administration?
I have only seen one definitive agreement.
Okay.
What Morales sent to Panton, I don't know. I never saw it. It
But
could be
you
the
made
same
the
one.
statement, you made the statement at 225 that Morales sent the definitive agreement to Tracy Panton. So I'm just trying for clarity and for facts.
Well,
Understand exactly which definitive agreement are you speaking to or of?
I took liberty from what your Prime Minister said in Parliament. Your Prime Minister said that this email was an email sent with the definitive agreement. Right? Based on what he said, I'm assuming that this email was sent to Honorable Tracy Panton with the definitive agreement attached. If you look at the email itself, there seems to be an attachment here that says Def A. I'm assuming that that's definitive agreement, especially since the subject of the email is definitive agreement protocol. No, that actual email that was sent with that actual attachment that's there, I can't open that because I never received that email. Now, that may or may not be the same one that this cabinet, May 2023, tried to have passed. I don't know. But I'm only aware of one. I've seen one signed definitive agreement.
All right, sir, and that was signed again by who?
Gulab Sharma.
Which minister?
Erwin Contreras, it appears
Okay.
to be that it was signed by him.
All right.
And it also appears that that same agreement, this government took to cabinet and tried to have passed.
So, but you earlier said that you are unsure if there are more than one definitive agreement, but now you're saying that is the one that is being brought before cabinet?
Senator, you're trying to do what I do for a living, man. No, I didn't say that. Listen,
I'm listening,
I've
sir.
seen one definitive agreement that's been signed.
Okay.
There may very well be 100, but I have seen one that was signed, and I have seen that that one that was signed is the same one that this cabinet tried to pass in May 2023 as law with attached legislation. Those two are the same for sure.
Okay. This definitive agreement, as was asked earlier, you confirmed that it is unusual in number 33 to have a confidential clause, correct?
Well, yes, I did say that.
But
I would
this,
say
this definitive agreement was signed under which administration? The one that is before you right now?
one under the UDP administration,
Okay.
and it was attempted to be passed into law by this current administration as well.
So help
We
me
signed it.
help me to
We
understand.
signed it, and this government adopted it, or tried to adopt it.
So is it, since you sat on the Cabinet Subcommittee for Investment and
Yes.
this definitive agreement never was brought to the committee, how is it then that Minister Erwin Contreras would have had the power to sign this definitive agreement?
I disagree that he has the power to sign it. I disagree. I would say, as I said before, that not only does he not have the power to sign this, not even the Minister of Finance has the power to sign this agreement. So I am not saying that he had the power to sign it. I think it's an empty document, dead on arrival. So it begs the question, why is a document dead on arrival, certified by one of the best attorneys in the world to be dead on arrival? Why would this government try to pass that same document against the advice of the lawyer they hired and try to give legislation to give life to a document that they later said is not a good document? But I guess that's a job for the committee, if the Prime Minister ever appears.
Honorable Parafit,
Yes, Senator.
what is your position on cabinet papers in terms of confidentiality?
My personal view?
Your professional view as it relates to your position as a senator.
My professional and personal view is that nothing that is the people's work is secret.
Okay.
And I believe personally and professionally that anything discussed in the name of the people is not private. And I believe that a cabinet confidential is a joke. It's an oxymoron. There should be nothing as a cabinet, in my personal view, you know, because I believe that anything that cabinet discusses that is not a national security issue should be made public, in my view, personal view. Of course, I am at times outvoted on that view, but that's my view and I won't ever shy away from that view. I believe that anything done in the name of the people cannot be secret, except for national security matters. That's my professional and personal view.
Okay. Can you share with us what or when confidentiality can be broken from a legal and from an ethical perspective?
Wow, that's a broad question. No, I believe that confidentiality can be broken and there should be repercussions if two people violate a private agreement.
A private agreement?
If there's a private, if you and I in our personal capacities buy a house from each other, or buy a car from each other, that's private.
It can be broken then?
Well, if that's the agreement, if I don't want anybody to know that you sold me a car, we can put it in the agreement, that's fine. But I do not believe, I've always objected to, have been outvoted on many occasions, that there should be nothing about confidentiality when it comes to government and the people's business.
So that is your personal position?
That's my personal profession. You want privacy? Go in the private sector.
Okay.
You want nobody to know what you're doing? Then go in the private sector. But when you are being paid by the people's money, by the taxpayers of this country, you can't tell your boss that there are certain things I can't tell you.
Okay. At a professional level, in terms of cabinet, at the level of cabinet, can you indicate to us if there were issues as it relates to whether or not members of the House objected to having cabinet papers released prior to now?
No. The worst kept secret, the worst kept secrets was a UDP cabinet. People knew what was happening in a UDP cabinet the minute it was happening in live time.
All right.
There wasn't any secrecy, there wasn't any distribution of cabinet papers, and there was a, you know, like a Hulk Hogan type of personality to say, give me back the paper, give me back the paper. No, it was like, here's the paper, let's discuss it. If it became public, it became public. There was no, and all of the things that came out of the UDP cabinet, Prime Minister Barrow's reaction was the same every time. We live in a democracy. There are no secrets.
Okay, thank you for that. Honorable Panton had stated earlier that cabinet papers are confidential. Your position is, as you had said it earlier, you refer to it as rubbish, and you've made it clear from your personal perspective that cabinet papers should be shared, correct?
Yes,
your latter part.
I believe that,
yes.
that they don't necessarily have to be shared if people don't want to see them, but if people want to see them, they should be allowed to see them.
Okay. Okay.
But opinions differ. Opinions differ. My position is there can be no secret about the people's work, none, except if it's going to affect national security or a strategy that we're doing, only then. But there can be no secret about things as harmless as a contract.
Do you agree that confidentiality clauses are important in definitive agreements?
If I believe they are important?
Yes.
No, because I think they're useless. Because then a member of the public can simply write to the Prime Minister and request the agreement. in my view, nothing in the agreement can override the law. And the law says that any member of the public is entitled to know or have access to any document or information that is being possessed by the government. That's the law.
And by law, you are referring to which
The
law?
Freedom of Information Act.
Okay.
I have a right, you have a right, any man or woman on the street has a right to write to the Prime Minister and say, I want to know how much this Senate inquiry is costing the taxpayers' money. And they have to be told that. That's the law.
Okay. Can you share with us one last question? What are some names that you can recall that has been brought to your attention as it relates to the Portico definitive agreement?
What do you mean names?
What names can you recall
Yes.
that has been in relation to the Portico agreement?
Well, I remember that Mr. Gegg, whenever we had a presentation to be made by Portico, it was always David Gegg. And then when I did a search of the company Portico, I noticed that there were two shareholders, Mr. Gegg and Mr. Gulab Sharma. Those are the principals by law of the company.
Okay. You have made mention of Morales.
Yes.
Morales being as in first name, there's a first name, or there's that Morales meaning a law firm, Morales meaning
David
Mr.,
Morales,
Mrs.
an attorney at law. Mr. David Morales, attorney at law.
Okay. That's my line of questioning. Thank you, sir.
Senator Williams? Any other follow-up questions, colleagues? Senator Bennett, can you take off your mic, please? I have a few follow-up questions, if you allow me further. How was it, what were the protocols put in place as much as is reasonable possible for confidentiality about prospective investments? Using this topic as conversation, ownership of land in particular areas of the country would have been very relevant. So how was it that there was some confidentiality in terms of what the weight of interest was from the government to ensure that if Crown land was in fact Crown land, that there wouldn't be all of a sudden discussion or circulation so that maybe there would be interest in acquiring said land for project sites and that so forth?
I'm not aware that there was any speculation about any land or anything like that. Take Portico, for example. One of the questions we had after the MOU was signed is, how are you going to put a port on property that you don't own? We have to be satisfied as a government, as an investment committee, that you are able to do what you want to do. The response of the developer was that they were going to take care of that. And our response in one of our meetings was, that's not enough. We need to be satisfied that you have a title or an agreement in principle or something to that effect. That's a matter and a problem for the developer. That was not a concern of the government. If you want to ask the government for certain courtesies as it relates to a project you want to do, then the government will not help you qualify. You have to be able to qualify on your own. So I don't know what happened after the questions were put to the developer about the ownership of the land. I don't know how or from who or when or whatever led him to acquire the land. I don't even know if currently he owns the land. I don't know. But I know that it was never presented to us that he owned the property upon which he wanted to put the project.
So what was the basis of this getting as far as it did get in terms of the investment subcommittee? We heard that it arrived, section 4, stage 4 had been completed.
Well, I mean, like I said, the MOU is far from binding. It's far from certain. It's just that the government is interested in a concept. You come with an excellent idea, the government is willing to explore that idea. However, once you get past the ideas and the airy and dreamy concept of a project, what we do is we tell you, listen, we are interested. We have a memorandum of understanding that we want to explore this thing. Once we get to the MOU that we want to explore, part of exploring it is determining your ability to do the project. Like one, portico, number one, where's the money? We're an investment committee that deals with $10 million and above. Where's the money? Why are we sitting here, 5, 6 ministers, wasting time listening to presentation, and you can't satisfy where you're going to get your money from to build? Where's the commitment from a bank, from somebody? Where are you going to build this thing? Because if you just want dead raise, then the government can do the project themselves. Secondly, the land that you occupy, where is that land? Who owns that land? How are you telling us that you can build something on the property that you don't own? No. So you're past the dream stage and you're getting into what we call the nitty-gritty. And thirdly, environmental clearance. Is this environmentally friendly? That's one of the big criteria that you must satisfy us, that you are satisfying. And so before you get to a definitive agreement, between the MOU and the definitive agreement, you have to satisfy us, yes, you have the money. This is your land. And 3, you have gotten environmental clearance. So that is why I was shocked when I heard that possibly Portico has a definitive agreement, because as far as I knew, there was no environmental clearance. And that was the process.
The process you've outlined to us today, I understand, is the practice.
Yes.
Is there anything that you can point to that it was rooted in law, that there was a technical requirement for your former ministerial colleagues to follow, to adhere to that policy and practice?
What you mean technical?
That they couldn't, as ministers with a portfolio in any given area, that they couldn't on their own enter into an agreement outside of the process that you outlined, which was via this investment subcommittee.
Madam Chair, I wasn't in cabinet when the investment committee started, but from the moment I became a part of it, it was explained to me by the Prime Minister, it was explained to me by other ministers, it was explained to me by the chair, by members in the investment committee and the full cabinet exactly what the protocol was. Nobody was under any confusion as to how this worked. And you know who else was under no confusion as to how this worked? Portico. You know how this worked. You know how this works. You know that you cannot have one minister sign a definitive agreement without cabinet approval. You know that. Everybody knew that. Everybody knew that the investment committee nor any member thereof could sign anything, commit to anything, bind the government in any way. Whatever we wanted, even if we had a recommendation that we were making to the cabinet, when we took that recommendation to the overall cabinet, that recommendation was subject to rejection because the cabinet had the final say. And so no minister could, as we say, play last and think that there was some confusion about how the investment committee and the cabinet operated. We all knew, because every time the matter came up in cabinet, and it came up almost once a month, because that's when we had our meetings, it was repeated over and over and over and over again.
So you would reject this statement: there is no edict law which states that the approval of the cabinet of ministers' approval is needed in order for a minister to enter into an agreement with a private entity. Such a policy would lead to absurdity and bring the business of government to a halt.
I don't know where that statement came from. There are laws and there are lawyers, and it is true, you pick 10 lawyers, you get 10 different opinions. there is one school of thought that a minister can bind the state. I think that's maybe why the Prime Minister, when he first came out, said it's binding because Minister Contreras signed it, it's binding. There is another school of thought that no single minister can bind the state to that effect. That's one school of thought. However, this is the caveat to that analysis. Under our cabinet, there is a thing called legitimate expectation in law, which I believe that our cabinet established. Whatever you may think in your head, the rules, whether policy, formal or informal, of this cabinet is that it goes to an investment committee who then recommends an MOU. The cabinet approves it, for example. Then you go through checks and balances, and then you come back for a definitive agreement. Once we all accept that that's the procedure, it develops a legitimate expectation. Let me give you an example. State Bank Enterprises has a legitimate expectation that anybody who wants to open a cruise ship tourism facility would have to go through the same thing they went through. You cannot tell State Bank you need A, B, C, D, E, F, G before we sign a definitive agreement with you, and then another entity, you don't need any of that and go straight to a definitive agreement. You'll be breaching legitimate expectation of people who had to suffer what you don't want to suffer.
And this is repetitive, but once more for the record, you, beyond the document that we have shared with you today, you did not have any involvement in any alternate drafts, any iterations other than that. You were not involved in creating that draft, advising on that draft, reviewing that draft in any way, shape, or form?
No. I certainly would have spelled definitive correctly on the first page.
Yes or no?
I said no.
Okay, I'm just making sure.
I had nothing to do with this document. I didn't draft it. I didn't negotiate it. I didn't deal with it, because then certainly any government attorney, any attorney general who would agree to this should be shot. And any cabinet that tables this in a cabinet meeting, and any prime minister that tells his cabinet, pass this agreement along with this legislation. I won't say what I say about the Attorney General, but anybody, any government that does that is not a government that's fit to lead. There is no way that you can sign a definitive agreement where you blatantly want to break certain laws. You had asked me earlier, and of course I can't find it now because I want to find it, but this, for example, gave Portico, when it comes to legislation, exempt their subcontractor and subcontractors from payment of any and all customs and excise and revenue replacement, stamp duty, general sales tax, environmental tax, income tax, business tax, contract tax, and withholding taxes. Exempt the developer, its shareholders, funders, and the EPC contractor from payment of income tax, business tax, capital gains tax, withholding taxes, or similar taxes during the term. Exempt the developer from stamp duty payable on the allotment and or transfer of shares. The terminal, the project facility, the project. Who would agree to this? And listen, this is what this cabinet, this John Briseno cabinet, tried to do on May 15th.
I just have a follow-up.
Incorporate the agreement, this agreement here, that I said any other should be shot for. This agreement, incorporate the agreement as part of the legislation and otherwise ensure compliance with the government's obligations hereunder. Tax stabilization. If they were paying a certain tax today and tomorrow the government would increase the tax, they would not have to pay the extra tax like every other corporate citizen. So no, Madam Chair, no, Madam Chair, I would never be a part of drafting this, nor agreeing to this, nor promoting this in any way, shape, or form. My daughter would be ashamed.
Regarding the due diligence on ensuring that, as you said, the committee, the 6 ministers' time was well spent, how much are you able to collect went into due diligence on this investment group to make sure that this was bona fide, there was funds there, that this was not just...
You mean Portugal?
Yes.
Well,
were you a part of that due diligence?
Yes. We were a part of asking them for information. And we discovered that it was a company created with about 10,000 shares, with 2 people subscribing to 100 shares each. What part of that indicates that you can raise $300 million? That was a red flag right away. Secondly, you didn't own the land. Secondly, you didn't have environmental, thirdly, you didn't have environmental clearance. And there had to be an assessment because, and I still think it exists to this day, the person who owns the right to the port of Belize, Belize City, the cargo port and the port, supposedly has a document that covers that area that Portugal wants to build, that gives him the right of first refusal to build. All of that we could not explore because we ran out of time. The government changed. I assumed that this government would have continued that search, but they didn't. So, from our investigation of this, and I'm not singling them out, there were other people who wanted to build an airport, and when I investigated them through Interpol or through our other people, they never built an airport before in their life. Their entire corporate structure was fake, and we have to do all of these things to make sure that these people who want the help from the Belizean people to invest in the country are legitimate and capable of giving that help. So yes, we did the due diligence, and we were not satisfied with the due diligence enough to go to a definitive agreement stage.
Outside of your work as senator now, do you have any further connection with Morales and Company? Is that law firm still active? You are still a partner?
No. No.
You have any professional relation, connection with that?
No, the company, the LLP was dissolved, the partnership was dissolved by mutual consent, and you know, I don't believe that this committee, no, this is a private matter. I don't believe that the committee has a right to know about my private law firm business. But I will nevertheless answer and say that when you are in business and you have differing interests and different styles, but you've been friends for 40 years, you reserve the right to walk away respectfully, and there's no issue.
Could you
There's no issue, and I maintain, I don't want the impression to be given that when David Morales called me, when he called me in May or so about 2020, he wasn't calling me with no malintent from what I gathered from the conversation. He was simply inquiring, well, what do I do now? We have an MOU. What do I do now with this definitive agreement? Who signs it? I saw you sign the State Bank one. He was just asking questions that he should ask. He wasn't trying to do anything untoward, not in the conversation I had. But when your interests diverge, then it's best sometimes you sever the partnership.
And just as a matter of fact, that divestment between the both of you for that law firm happened when? Do you have a
Oh, I don't have that
date?
document on you. I never thought you'd be asking me about my law firm. But I can get you the document because I have the document.
Please.
But remember, I repeat, even if you are a partner, as I was in that law firm, and you become a minister of government, by law, you have to divest all investment of yourself and all involvement from that firm by law, or you could be disbarred. Your name has to be removed from the letterhead. And I made sure that all of that was done. I never meddled in the business. David was the managing partner of that firm, and he ran the firm as he saw fit, made all the decisions, because I could not be a part of the decision-making process.
Senator Perry, we want to thank you for your time.
That's it?
Sorry, I apologize. Thank you for your time, but we have a few more questions if you're able to spend a little bit longer with us.
Unlike the Prime Minister, I don't believe I have a choice.
Sorry, sorry, Senator Bennett Moody. Bishop Bengoshe, you want to?
Thank you, Madam Chair. Honorable Purvey.
Yes, sir.
I hear a term being used loosely sometimes. The term collective responsibility is what I hear, and I need to ask, during your time that you served as a minister, was it a term at any time used in order to come up with a decision?
No.
Thank you.
That was not, if I may expand on that, Senator, it was not in cabinet. The cabinet consists of grown women and men. If you don't like what's happening in there, you resign. There is nobody there mandating you to hold a position. You are free to hold whatever position you want to hold. But I think it's incumbent upon me, for example, that if I am not satisfied with what is happening, I should walk away and walk away from that. At no time did I ever believe that the UDP cabinet that I sat in was acting in a way that I should walk away from that. Because then I can't blame collective responsibility on my reason why I stay. If I'm not satisfied, I resign. So I think it's a coward shield that people hide behind. If you don't like it, resign. You don't like being a part of this group or a part of whatever, step away.
Thank you.
Senator Bennett Mooney.
Senator Perfy, just a few more questions, please. If I recall correctly, you said at different times, different ministers or even your office, former AG, would have been able to sign off on definitive agreements. Is that true? Or
whenever instructed by cabinet.
When instructed by cabinet.
Not on our own.
Okay. Can you recall being at all cabinet meetings during your term? You can.
I can clearly recall that I was not at all.
Okay. All right.
I'm not even at all Senate meetings.
All right. At 3:35 p.m. this evening, you stated that Portico knew...
You sure it wasn't 3:36?
3:35 p.m.
Okay.
Portico knew that Cabinet had not approved a definitive agreement.
Yes.
On what grounds would you make that statement?
Because the process was explained to all prospective developers as to how it would go. And let me give you the State Bank example.
So just before you get there, before you get to your explanation, so you're saying that, yes, you may not have been in cabinet at every given point when a decision is made. Is that so?
Senator.
Despite the fact that there are steps that are outlined, but is there a possibility that a decision was made when you were not in cabinet?
To approve this definitive agreement?
Yes.
I will go out on a limb and say no.
Okay.
I would say that Prime Minister Barrow or any sensible Prime Minister would not approve any document without her Attorney General present.
Okay.
And he was very sensible.
And from your recollection, during your term of office,
yes,
were all decisions by cabinet made public?
No, I don't think so.
Can you elaborate as to why and why not?
We had cabinet releases from time to time, as does this government. You inform people, but cabinet, listen, cabinet has very limited power, you know. You knew that? There's not much cabinet can do. Cabinet only executes the law and execute the policies of the government. For example, cabinet can only discuss what would be the policy of the government as it relates to certain laws. But cabinet cannot override laws. Cabinet cannot decide tomorrow that murder is legal. Can't. You have to come to the National Assembly for that. Meaning then, there has to be a public aspect where the people are hearing you make that decision. Cabinet simply executes policies and informs the public after every cabinet meeting as to what the position of cabinet is on various stuff. No, we don't always go into the deliberations as to who agreed with what, who supported what was the majority of. No, we don't normally give that information, but I don't think that information should be secret either.
Okay. So for the record, you are saying, if I understand you right, that Honorable Erwin Contreras would not have had the power nor the right, nor did he get the directive to sign this agreement dated 1st October 2020.
I believe
Is that
I've
so?
made that perfectly clear.
All right.
Thank you, sir. Clear.
Senator Carl?
Senator Perfit, just to go back to the statement that you made earlier, that you knew that, again, you repeated it when Attorney Morales called you about about a definitive agreement.
Yes.
Can you state on the record, did you even, as the Attorney General and as part of the subcommittee, did you even question that agreement that was mentioned?
No.
So you didn't care about what agreement was being sent or what that was mentioned?
Senator, eventually when you become a minister, you'll understand. You get 1,000 phone calls a day with 1,000 different things. I was confident that we had a structure in place. I was confident that we have a structure in place executed by Beltrade and the Ministry of Investment that I didn't need to worry about that. If you have something that you want the investment committee to consider, send it there. And when we meet, we will discuss it. That was my feeling. It wasn't important that I receive it personally or first. Or if it is to reach the investment committee, it will reach.
I mean, it begs the question because it seems like every document that you hear of now, you even write using the Freedom of Information Act, but back then you did not even try to question that definitive agreement,
well,
even though it was mentioned to you.
Well, Mr. Morales, I don't have to question Mr. Morales. He was willing to give me, unlike this Prime Minister. Mr. Morales was willing to give me the document, unlike this Prime Minister.
But you could
and
have,
he's not a public entity, he's a private attorney.
But it was a definitive agreement with this port, and you didn't even question.
Exactly, because then I believed I had no authority to look at it personally and analyze it personally without the investment committee looking at it as well.
Did you even mention it to the investment committee that you got a call from Morales?
No, I'm not going to preempt them. Why would I preempt them? Because then what if Morales changed his mind the next day and said he didn't want to send it? I mean, if it is to be delivered to the investment committee, it will be delivered.
Thank you.
Senator Herrera?
One quick question, Senator Perfit. You mentioned that there's a law which prohibits you from being a member of a law firm once you become a member of government.
Yes.
Can you draw our attention to what legislation?
Yes, it's a legal professional. Attorney General, sir, can you assist me in that? I know I'm not paying you the $1,000 an hour that this committee is paying you, but it's in the legal professional rules. I can get it for you.
Sure, thanks.
Are you making a note, Madam Chair, of what I'm promising to deliver?
Yes. Senator Bengushe?
Honorable, I listened to you very carefully, especially as it pertains to freedom of information. And notice I keep hammering that aspect.
Yes, sir.
And I cannot agree with you more. Because a part of my research in preparation for this committee sitting was to look at 49.1.
Of the definitive agreement?
The Belize Constitution.
Okay, okay.
Which speaks also to the Secretary of the Cabinet and his or her responsibility as a public officer. And I emphasize that word public because I would have to agree with you that whatever comes out of cabinet, to a large extent, the public is due some kind of information. It is also to that person, separate and apart from any other minister, that we should look to in order to share that kind of information with us. And so, as I hear you emphasizing the Freedom of Information Act, I also, Madam Chair, need to also point to that it is that person who also have a responsibility to be able to share some information with the public. Thank you.
And that is why most cabinet releases are done by the CABSEC, to reflect the decisions and possible deliberations of the cabinet.
I think we're, again, continue to be grateful for your time and ask that if at a future date the committee is minded to ask you to return, if you would also join us to provide information related to our work.
And I repeat, Madam Chair, I believe I have no choice. It's my duty.
Thank you very much. We will adjourn the session at 4 p.m. Sorry. Suspend at 4 p.m. Thank you very much.
Thank you, Madam Chair. Thank you, members.
Thank you. Can I ask members to just join briefly in the committee room, please?